matter, Your Lordship.
Give a memo.
I'll give a memo.
Yes.
Item number 2. These matters are not registered.
I know. I know. What is the defect? In the event the defect pointed out by the staff reporter is not
Also, Lordships leave, I'll appear virtually, Lordships, in the matter. Lordships appearing virtually in the matter, Lordships.
Why are you not removing the defects?
My Lords, I undertake to remove the defect, Lordships, within 2 weeks, my Lords. Only 2 pages.
There are 2 pages are illegible.
Please, Lordships. They're relevant pages, Lordships. My mistake, Lordships. The instructor told to replace the pages.
I'm so sorry.
Item 5, sir.
Your order is not to be reviewed. Take care of that. Work.
But the petitioner has presented his application.
What?
It's a pain in heart and mind. I'm sorry to say this.
Why? Why the pain in your heart and the mind both?
That's the reason being. It's very recently, matter was heard by my Lord's Lord, this honorable bench Lords. Just the issue before Lordship Lords, which was addressed by the counsel and petitioner in this case is, 151A, the faceless assessment scheme, which was mandatory, Lords, and that was brought in judgment by Telangana High Court, which was affirmed. Impliedly, Lordship said the other day, implied affirmation. Within one, Lords in Telangana, in Raman's case, that was a detailed judgment. But in another case, that is in case of Dipanjan Roy, that was followed judgment of that Raman followed. And in the Dipanjan's case, Supreme Court said that no error, and that's affirmed. And he implied affirmation, Lordship. But that is what your Lordship done in detail the Telangana judgment Lords, and said that yes, that will apply and the order should go. And your Lordship has specifically also said the other day, perhaps in view of all these grants, perhaps the matter is allowed. Your Lordship, yes, it's allowed. But somehow perhaps the matter is kept reserved for judgment. And my Lord Honorable Justice Raman has also delivered detailed judgment of 35 pages. But somehow or other now it is dismissed.
Certain factual aspects we found from the report. Certain factual aspects we found from record, and I have said there is a distinction can be drawn.
There is a distinguishing feature so far as the factual matrix is concerned. And
regard to that jurisdictional aspect also, you can very well take up before the appellate authority.
As my Lords know, my Lords, normally the procedure, my Lords, all along adopted by this honorable court, in case of any variance after Lordship goes back and dictate for judgment, my Lords, and then matters are usually kept for to be mentioned. So that matter can be more clarified and opportunity granted to counsel to focus on the issue, my Lords. Because when I go with smile and come back with pain, my Lords, that is what, my Lords, it's a live streaming, my Lords, all proceeding. Everything I have gone 10 times the live stream, the clipping available to me. And I went through and find that, in fact,
how can it be made available to you?
It is there. In a website, public domain, it is available. Public domain, it's available.
Why it is not supposed to be recorded, not supposed to be kept for that? Because the disclaimer is already there. It is only for the purpose of viewing, not for the purpose of...
Disable it. We cannot disable it, but it is available. In YouTube, it is available. Always. In any case, mirrors. My humble
a notice on you and you come with your objections within 2 weeks. Come with the objection. Yes, 2 weeks.
Item number 6.
Production of multi-purpose cyclone.
This last one.
It has a substantial value in the market. It is that red rock with pores, like it. And entire Bhubaneswar.
We shape, only, bring out, into sizes.
Yes, it is cut into
The Makada Pathar.
market, exactly that type.
Buildings.
That is exactly the term.
Is it stone or is it dust?
It is a fine dust kind of which has crystallized or calcified into stone. I don't have much scientific knowledge, but whatever I know is calcification of the soil into hard
The solidification.
solidification.
This is commonly known as.
Rich in iron oxide. This is rich in iron oxide.
What I know is as a surki.
I'm sorry, man.
Surki is the word.
Turkey, man. Man. So now this was
In those, the Roman, the way of constructions. They used to use this material for the construction purposes instead of, because at that point of time there was no invention of cement. So these were used
man,
with a lime, with some kind of a
Chuna,
jaggery.
live and all that.
Lime, jaggery, they used to mix it and then make the construction.
That seems to act as a binding
So this was one of the very essential ingredients
man.
for making a construction.
Right. Right. On old structures, you'll actually find before
Roman era, talking about
We use it on roads.
we use it on roads also.
the Gothic structures, when you prepare, these are the raw materials which are used.
So these are value in the market. That's why
There's lot of value.
lot of value actually. Now, this is one such case which has been brought to your lordship's notice, Manus. Here, the rules have been fragmentally violated. I would say that there's a illegal deviation of the rules. Illegal deviation of the rules, even though not expressly impermissible, but the manner in which it has been done is extremely irregular. Does not appeal to common sense at all. 33,000 and odd cubic meters have been advertised. The petitioner takes that in the auction. He quotes a particular rate. He signs the agreement, also is signed on that rate. The environmental clearance is taken. The mining plan is also approved for 33,000. Then Mallard's consent to operate is also taken. He operates for some time. And then he suddenly, Mallard's, without any rhyme or reason, he goes in for a modification. Now, the lessee, opposite party number 11, goes in for a modification from 33,000. As per the mining rules,
Yes.
no, 3,000.
Okay, reduce.
Reduces. And accordingly, with the mining plan also gets reduced and everything gets reduced. But then, Mallards, had it been what meets the eye, it's not so, Mallard. Had it ended or stopped at that, Mallards, the writ petition would have never been filed before your lordship. Here is para 16 of my writ petition. Even though on paper it has been modified to 3,000, now in reality, the ground reality, Mallards, huge number of trucks are going. So he is, Mallards. So now, illegally he is taking away and he's clearing over a far larger area.
If a person has been granted the binding lease for 33,000, and if he wanted to reduce it at 3,000, then that's the
Permissible.
that is that he does not want to excavate those minerals beyond 3,000 because he does not may not found it or find it viable.
Maybe.
So if he stacks the truck or the trucks, that does not mean that the mining activities is beyond the revised.
There can be no argument against that logic of the
Presumption that
The reality on the ground is different. Reality on the ground is, Manoj, I have pointed out.
because you said that there are large number of trucks placed.
Yes.
That shows that does not mean It may be within that 3,000 cubic meter.
No, 3,000, the capacity gave the 3,150 trucks. You not even can you look at.
How did you place it?
Man,
If
here-
they do the mining activities more,
Your Lordship may kindly have a look at the petitioners, the representation is, they have given a representation, my lords. That is, your Lordship finds that in annexure 12.
whatever.
What is happening, my lord?
Why? Maybe that they are starting
There is a huge demand for this material.
that you have potentials to sell.
Man,
Many may not have a potential to sell. And it all depends, sir. I mean, economics stupid.
man, I perfectly understand the business economics, man. The
So
question is here, the allegation is
sometimes the price is also one of the factor.
maybe.
The quality may also be a factor. Sometimes the intending buyers may also be factor.
That,
Sometimes the terms and conditions of the sale is also a factor.
all that can,
Somebody may sell it on a credit.
so that.
Somebody does not want to sell it on credit on
Man,
immediate payment.
there can't be any argument against that, man's proposition falling from your Lordship.
We are placing the truck does not mean that he is.
You're not placing, my lord, they are applying, your Lordship. Can you appreciate?
Implying, sir,
Man,
there must be something which should be brought on record that they have expanded that particular area despite.
Man, that
the
is what-
same have been reduced.
man, that is what, your Lordship can envision.
And I do not find any reason for that. Thus, once he has been granted a 33,000 cubic meter, then if he decided to squeeze it to 3,000 cubic meter, he will go beyond it. Had it been his intention to go beyond it, he would have not.
Things were that, if things were that simple, man, there would not
That
be
is
so many,
appears to me a very simple one.
there could not be so many, man.
I do not
Such
know
a lot
who
of
wanted that.
entire area. Your Lordship may kindly appreciate annexure 12, the entire area, man. There are so many representations. 3 pages
But
of.
the difficulty is the representation, sir. Anybody now, whatever this is their ball, the ball is in their court, they will take care of that. That does not mean that anybody will put a spanner to running of the mine activities.
Man, nobody's putting a spanner.
Granted.
No, what I want, your
Somebody,
Lordship.
I would say the interloper, somebody who has
I-
a busybody, will come and make allegations and then come to the court, give it. I have gone there, consider my allegation.
Man's representation, man.
Sorry, I have a very strong reservation for this representation theory.
Man, I have, I'm a.
Show us the material that there has been an infraction. Merely placing a truck will not do it. Show us any material. You have asked for anything.
Manoj, we had asked for the earlier tender documents because the allegation is that the local administration is colluding.
From your submission, it is very, very clear that there was an auction for 33,000.
Right.
He stood first and lease was granted for 33,000. Later on, he has told the authority to reduce it to 3,000, which has been granted. Now your allegation is that he is excavating that particular whatever the sand. So beyond 3,000.
Much beyond 3,000.
What is the matter? What is the evidence? What you have gathered? Mere oral statement will not do. The difficulty is that by just making a representation, you are really burdening the authorities without any evidence to come. You should gather some evidence.
They have also said that we approach the authorities,
Whatever,
but
on mere assertion,
that's an
you
assertion.
must give some supporting document that this, look, these are the documents. Or something you have asked for under the, how can we exercise the advisory jurisdiction? And why should we You know how to
Months.
do it. Yeah, this is not a proper way of process.
I leave it to your lordship.
One evidence, one kind of something that, yes, this shows. And look, he has gone. Authority, they are periodically checking. I think that is within their wisdom to check. They are going regularly and finding whether he has exceeded or not exceeded.
Is something which we are, the fallout of this, the implication of this is that that is not being done. That is the implication, that the
They will do
regular
it. They
monitoring.
will do it. They will make a constant monitoring. In the event anything is found that he has violated the terms of the lease, if he has violated any statutory provisions, he will definitely activate. Nothing more than
The lordship gives such a observation also.
on this kind of a
Then your lordship,
presumptive and presumptive
No, I-
writ petition.
then your lordship may grant me some time to, I'll find out if there is something.
Why should we?
Mal, I leave it at that. I'll not take.
Evidence.
Mal, I'll leave it at that. I'll leave
And
it at
the
that.
court should not be used as a tool to.
No,
stop the evidence.
I'll definitely not
For you.
advance such a submission. I'll definitely not advance such a submission, but I thought, Malad, that this could be a public cause enough for Malad.
Maybe, sir, because.
Oftentimes, Malad, in PR, you don't have valid proof, evidence.
To do that, it does not mean.
But oftentimes, Malad, in PRs, we do not have direct, concrete evidence.
We appreciate that you are a whistleblower.
But
We
where
quite
the-
appreciate.
No.
Now they will take.
where there's a tacit,
But consider and take a decision in the representation. I
No.
have.
where there's a tacit complicity of the officials, Malad.
No, that asset must be corroborated by some piece of evidence.
There, Malad, it's very difficult.
Don't say mere oral statement will not do it, must be corroborated by some kind of an evidence. One piece of an evidence which really raises a doubt or raises a serious concern. Nothing. Simply you have gone there, you have seen lot of trucks are placed.
These are trucks.
You one fine morning, you just inculcate a sense that they are excavating
These are actually-
beyond the pumps.
These are actually photographs of trucks taken at different points of
Tell
time.
me from your own conscience. Can you?
At different points of time they have been taken.
The difficulty, there must be a multiple reasons that they are excavating every day and night. They are something, so they are not finding a suitable buyer. Suddenly one buyer comes. And those materials which are stacked, they wanted to transport it. It may be 200 trucks, it may be 300 trucks. It may be even 5 trucks. It all depends upon the demand and supply. That economics.
Come on. I'll leave it to your lordship. I'll leave it to your lordship. I'll not.
May I submit some developments in this list. After receipt of his representation, the Deputy Director Mines Jaspur Circle, he has already given it to an agency for conducting inquiry. The agency has already conducted inquiry, observed the mining activities for 2 months, and as per my latest instruction, agency has prepared the report and the report is placed before the competent authority for vetting. This development has occurred in this matter. After receipt of the
So your purpose is served.
No, not to
Your
be.
purpose is served.
That may be recorded and disposed. Fair and extremely fair. My friend is extremely fair, man.
So the
He
entire
does not
purpose is
say
served.
Lordship may record that and dispose.
This is the public interest litigation.
Man, it's public interest.
The instant
Yeah,
public
I-
interest
I-
litigation.
That's the prayer number 2.
Prayer number 2 was my main.
Yes.
Item 8.
Let me your lordship. That petitioner will have the approval public skills state person will expound the cause of the villagers whose right to path has been blocked by
Right to
pathway, the road below. Road is blocked by the existence of a club. Now
existing
there's a clubhouse
club.
on the edge of the road. Where the
Who has constructed a club?
there are some people, some villagers, some youngsters of the village, they have constructed. We have raised objection. We have raised objection to. Well,
He is flagging an issue that there are many illegal occupants. Why are you not taking the steps against them?
Malas will see paragraph 5, my lord. One part of the road has already been made enforcement free. And they themselves write over 100 people have been evicted. The other part, my lord, also notices have been given. In paragraph 5 and 6, the petitioner mentioned. Malad will permit me to take instruction on the present status, my lord, whether what is the.
Do one thing,
No.
while a very short affidavit,
No.
just disclosing the steps which you have taken. It does not require the dealing of those allegations. It is a
No.
public interest litigation. You are not an adversarial litigant. So we are all at one. So
No.
just come and just show us very 4 or 5 paragraphs, show us that what steps you have already taken
No.
in relation to. That's all.
No.
It will be. Yes, we speak with the.
The last order dated 4/9/2025. State was supposed to take instruction on. Here, this is the matter, my lord, last revision said to remind my lords only. This is a matter in 2021 query was granted for mining lease in favor of the petitioner by the revenue department. I continued the mining operation for about 2.5 years. And suddenly, by virtue of amendment of the OMC rules, so records were transmitted from revenue department to steel and mining department. So immediately on the date of transfer, this mining department stopped my mining operation. So indicating that these are the wanting documents. Well, for 2.5 years,
The Tehsildar did not transmit those documents.
that is their allegation. For 2.5 years,
That means the Tehsildar is supposed to transmit those documents
it
because
did not submit.
you submitted those documents with the Tehsildar. Is
Yes.
it?
Tahsildar did not send all those records. And
So
mining,
it is, according to you, if somebody else has committed a fault or default, then why the other will be penalized for
Yes.
it? That is what I am.
Anyhow-
Reading and you are saying no.
yes, no, anyhow,
I am saying something in your
yes,
favor.
anyhow, I again submitted all those documents with the mining department. Now, under Annex 12 and 13, I have represented. Kindly allow me, my mining operation is going
How
to.
can you stop the mining activities if the Tehsildar has failed to submit the document, which he has submitted to the Tehsildar? Then he should be penalized. When he has not committed any wrong.
Absolutely, absolutely. My lord, I have got the instruction, my lord. He has submitted all the documents on 3/3/2025. Thereafter, the deputy
You
director.
will make certain observations on that.
No, my lord.
And make,
My lord,
you will not spare
that's
this.
a kindly. Here. The deputy director of mines of the Raukala circle, he has sought for clarification from the director of mines, my lord. Yesterday, then.
Or
Yes, my lord.
if the lease granted by a competent authority has not expired as of date, can a change in law where the authority is transferred to somebody, that lease will automatically come to end or will be cancelled? Is this a law?
Now they have.
I fail to understand why clarification would be sought for.
Now,
It is a lease which has a duration. The duration has not ended. You can't put a finger unless you show that he has violated any terms and conditions of the lease.
now they're going to take a decision within 3 days.
No decision. We are directing them to continue. We are directing the issue of mandamus to continue with the mining activity. Let us take up the, though I am always against that particular principles, that no mandamus in that nature should be issued. But this is such a case. I am really surprised with this.
There will be no necessity will receiving the mandamus that they will do. Let's say that in 3 days time.
The Tehsildar under the law was competent enough to grant the lease. The Tehsildar has granted the lease. The duration of the lease has not ended as yet. In the meantime, there has been a statutory amendments where the power of the Tehsildar is vested into a mining officer. Merely the power is shifted from Tehsildar to mining. All the action of the Tehsildar will go. Is this a law we have?
No, absolutely.
And there is no allegation that he has violated any terms and conditions. I can understand.
That will be 3 days time. Because
We are putting it on next Monday. If it does not, that's the last one. If you do not, then we'll. Sometimes the extraordinary situation requires extraordinary decision.
Monday will be.
Just imagine as you have said, right here.
More than 20.
And all this development, food development have occurred within 2 days. Let's call the matter Monday.
As a last chance.
The public interest litigation here, that the petitioner files this application for implementation of apiculture program, the honeybee program, in this honeybee apiculture development program. The state government in the Odisha, since there is a 2 districts severely mining affected, that is one Sundargarh and Keonjhar. The government exercise of Article 48 of the Constitution decided to develop the apiculture program in 2 districts. And the Sundargarh, it has been completed. And Keonjhar, money has been sanctioned 2 times. Tender in the COVID time was invited, it was paid, but they have not yet implemented. The object of the apiculture not only to keep environment protection, but also create an employment of basically scheduled caste, scheduled tribe people who is residing at Keonjhar, and to who are living below poverty level, to give employment. And the money was sanctioned.
Item 12.
Taken time to take instruction to matter. Last 2 occasions.
Raise the demand. You are challenging the demand.
No, challenge cancellation of tender, repeated cancellation.
No, you are challenging the annexure 1. Which one?
Annexure 1 is item 12. Fuel. I market item 12.
What? They have cancelled the tender.
Madam.
Can they not?
Madam, my humble submission is, this is the third time the tender has invited, government has cancelled it.
I am stuck up with the judgment of the Supreme Court in UP IBAM.
My lord, if you know last latest judgment, my lord, I have gone through my lord with the. That is from Vaishnav Subodh Kumar Singh Rathore.
Yes. You have simply look at it.
There, the Honorable Supreme Court has categorized two stages: pre-contract and post-contract.
Which I gave. But
Therefore, in the specific finding of the Honorable Supreme Court is that the authority cannot cancel the tender like this manner. Formulated this question of law manner. Lordship she page at para 33. What is the scope of judicial review of the actions of state in matters relating to contract tender issued under writ jurisdiction?
paragraph
33 manner. Page 13.
There are the two questions which were framed.
10 manner. And thereafter manner referring to all the earlier position and the lordship, the concept of public law elements, scope of judicial review in contractual matters have.
Getting is the question number 2 is important.
My lord.
Whether the action is important.
My lord.
And look at it, the question number 2.
My lord.
Which is decided.
We'll discuss the Supreme Court in para 55. Referring to the MP for project management purpose limited company purpose limited.
Please.
Just got not there para 55.
Yes.
This court held that earlier position of law that all rights against any actions of the state in a non-statutory contract will be governed by the contract alone and thus not amenable to the real jurisdiction of the court.
No. That is a different point. We are not on that. The question is, what are the revisions of a person if the government has decided to cancel the tender?
Next page, not the last question.
I think the paragraph 60 onwards is important.
Right. But that matter. The para 63 matter starts from para 63. Lordship, my beg my lord, permit my lord that para 55, para 55 next page, last portion. Exercise of writ jurisdiction. Lordship, subject final funds, that is there. Yeah, framed question can analyze the exercise of writ jurisdiction dispute at the
That
stage
is why I say that there are 2 or 3 things which are important. Because this judgment was, I put it that you should go through this judgment to go see her. In other matter or in this matter, I don't know. Please read that what are the tests where and when can High Court in exercise the judicial review interfere in a decision of the government in cancelling the tender or the or whatever the activities. Come to paragraph 65 of the judgment. The meaning and the true import of arbitrariness is visualized as precisely stated or defined. The question whether an impugned action is arbitrary or not is ultimately to be answered on the facts and circumstances of the given case. An obvious test is to apply is to see whether there is any discernible principles emerging from the impugned act. And if so, does it satisfy the test of reasonableness? Whether a mode is prescribed for doing a where a mode is described for doing a deed or act, there is no impediment in following that procedure. The performance of the act otherwise, and in the manner which does not disclose any discernible principle,
which is reasonable, may itself attract the voice of arbitrators. Every state action must be informed by reasons, and it follows that an act of uninformed by reasons is arbitrary. The rule of law contemplates governance by laws and not by human whims or caprices of the man to whom the governance is there. Control of administrative discretion is an important concern in the development of rule of law. And this is what they have started, that it can only be tested or interfere in case this action is arbitrary. Now, in order to arrive at arbitrariness, you have to show what action, what is the rule, what whimsical approach which they have taken. You have to spell out in your.
That is also matter of subsequently para 68, 70, 71, 68, 68 onwards, referring to Tata Cellular and other principles.
No, that is not, the judgment cannot be read in isolation to the facts.
Right.
Every observations which are made is to be read in the context in which it is used. So this is what we wanted to say. Here they say that I am directed to communicate the decision of the government, that the government, after careful consideration, and will cancel the tender. Now they have decided not to proceed with the tender.
My lord, I found the
What is the right which is accrued?
Because once, my lord, they have virtually accepted my tender. After opening of the lordship, for moment, my lord, being my lords of para page 69A, my lord, Annexure 5, the technical evaluation. They have taken care of everything, my lord. Page 69A, I have the Annexure 5, I have given the typed copy. Lordship table are last table, my lord. The administrative approval accorded head order number so and so dated 13/7/2023 of the government of Odisha DOWR. Technical sanction also effected on 16/2/24. And ultimately analysis has been made in the last para, page 78, column number 20, my lord. May I read, my lord, para, column number 20?
Yes.
I did not para plus 2, para 20, my lord, page 78, my lord.
What?
They have analyzed the entire technical sanction, everything, how the procedure as per the DTCN, they have adopted and followed. And there is no other reason for not to cancel at this stage. Lordship, for a moment,
This Subodh's judgment is to be taken into consideration, that they are entitled to file their affidavits. Because the court has analyzed the several office notes put on the files, and the evidentiary value and its importance of those notes to be taken into consideration. It has held in this particular judgment, that's the one of the only ground for interference in a cancellation of a tender is that the action of the authority is tainted with arbitrariness. If it is arbitrary, then the court. How one can perceive the action to be arbitrary is on the basis of the facts, and says that it all depends upon the facts of a particular case. You can't make a straitjacket formula to take every action of the government as an arbitrary.
I agree with my lord, 100%, my lord. My humble submission is there is a procedure prescribed in the DTCN how to award of the contract. How
Just reverse.
reverse matter. How
Is there any procedure provided how to cancel the tender? There's none.
that is
I
so far the
think
procedure
there
concerned.
is no provision anywhere.
My lord, that is, I have quoted, my lord, in my petition regarding the paragraph 6.3.15, where that is specifically, that is a special committee has to be formed by the administrative department. You also can see page 11 of my petition. Page 11 my petition. My lord, procedure. The committee has to be formed by the administrative department, by the finance secretary, law secretary, chief engineer, all the chief engineers, FAO, and who has to take a decision. But here is a case, after the recommendation was made on 30th January 2025, after sitting over for 7 months for reason based known to the authority, and even though the very administrative department has given the administrative sanction approval after technical evaluation and everything.
While your affidavit is not be decided in this way, we consider this judgment and after hearing the respective and the about the evidence, we think that the opportunity will be given to the parties to respond to the allegations made in the instant information. We
Item 13.
May I place under to Lord's permission and proceed further with the tender. Definitely.
Item number 13.
Lord, you already with annexure 1, your office might come to page 27. And it will also maybe some.
No, my lord, I will just point out why it is not payable at all. My lord, they have given, if your lordship should come to the next page, 20E, they have given a what should be the actual to be paid, what is paid, they say, and the differential. And on that basis, royalty, DMF, and that NFT amount has been imposed. I'll just take your lordships to the statute where the rates have been fixed. If your lordships
In the schedule of,
schedule,
it's a sand or what?
no, it's limestone.
That is.
If your lordships would come to entry 26 of second schedule. MMDF. Limestone,
LD grade less than 1.5.
1.5
Silica, then it's
90 rupees.
90 rupees.
Others 80 rupees per ton. So mine is, if your lordship should see the mining plan, what has been given, and the admission of it also, your lordships may come to first page 30. This is a letter which has been, my lord,
Issued by the director of
to
mines.
the director of mines
By the,
by us.
by you.
Yes. Where we have mentioned that the royalty is being paid at the highest grade, the reason being the silica is more than 10%.
So 80 rupees you have said.
We have said, and we have paid that. And your lordships may see the mining plan, which starts, my lord, from page 33, annexure 4.
No, that's true.
The chemical report.
The actual rate of royalty, they have this come to 29.
Yes, ma'am.
The actual rate of royalty, they have been 90. You have said 80.
80.
And that is the difference of 10.
10 rupees.
According to you, that so far as the silica content is concerned, it is above 1.5.
5%.
Correct?
Yes.
They say no, it is below 1.5%.
No, my lord, that they have not said.
No, because if you come to page 29 or
Yes.
28, come.
Yes, ma'am.
The first column, serial number, don't worry, month, just quantity. Then third column,
Yes.
it dispatched above 1.
Above 1.5.
Above 1. And the actual rate of royalty is this.
So they themselves admit it is above 1.5.
Correct.
So how
Entry is say less than.
less than 90, above others 80, which we are paying.
Sir, how
And-
can you, that's the apparent on the face
and-
of the record.
and
How
my
can
lord,
you-
I'll
That's
just,
the only thing.
no, there is already an interim order earlier on this
We don't
issue.
want interim. I don't believe in interim.
No, my lord, that is why, my lord, I
believe in
wanted to
final-
first.
Final and
Final.
that's straight away, that's the only dispute. You are claimed at 90, they say 80, they have paid 80. Justify how 90, that's all. Any test, laboratory test report coming to you.
But once a person claims exemption of laboratory test report, he has to make payment of the highest royalty mentioned in the CDP.
Where is the problem?
Your Lordship may kindly see the rules. That is Odisha Minerals Prevention of Theft, Smuggling and Illegal Mining and Regulation of Possession of Storage, Trading and Transportation Rule 2007. That is a state rule that is framed under 23C of the MM1.
It is a pure question of law, and I think does not require. Let us see the law.
Yes.
Yes. This is the Odisha Minerals Prevention of Theft, Smuggling and Illegal
Yes.
Mining and Regulation of Possessions.
And this is framed in terms of 23C of the MMDR.
Yes, which problem?
Your Lordship may kindly come to 10.
Rule 10.
Rule 10, Transport of Minerals.
Yes.
The sampling starts from 5, sub-rule 5.
80%, let me see. I have a bad habit.
I'm
of reading
sorry.
the whole
I'm sorry. I'm sorry.
Yes, sir. What do you say, 5 and 6?
But 5 and 6 regarding sampling and stacking.
No,
Your Lordship may kindly see 10.7.
no.
10.7, first
I have
proviso.
read it.
Well, first
How
proviso.
it applies,
Well, the
how
first,
it applies, the exemption is something else.
matter he sought for exemption.
Exemption of what?
Exemption of the sampling process, my lord.
No.
Yes, my
No,
lord.
there is no provision for exemption of the sampling.
Sampling is
You-
there, I have given the report,
But
the chemical reports.
The exemption of sampling is not provided in the statute. To us.
the Lordship may
It says that he can say, I am ready, consent has to be given, I am ready to pay the highest slab. Then the exemption or dispensation will be done. The
yes.
first and foremost thing is that he's agreeing to pay the highest slab.
No,
If
my
he
lord.
does not, then show us which provision.
Lord-
Exemption.
Your
I
Lordship.
have read these,
But-
the second proviso to sub-rule 7,
The first proviso, if your Lordship will see,
please read.
provided that in case the lessee declares to pay
So what is this? Declaration means I am declaring,
that,
don't go by the analysis, I am paying the highest slab.
yes,
Has he declared?
no, my lord.
To pay-
That is,
Then this first proviso does not apply.
but
The condition precedence is the declaration to pay the highest rate.
But that declaration, your Lordship may kindly see page 30 of the writ petition. He claimed for exemption
What-
for
what-
stacking and
what
sampling of
exemption?
limestones.
20 rupees.
Page
What?
30,
Yes,
page 30 of the writ petition,
yes.
he claimed exemption for stacking and sampling of the limestone.
This is what is required in the third or second proviso.
Your
This is
Lordship,
under the second proviso.
Madam, 31 is the exemption granted, page 31. Your Lordship may,
Please kindly come what is the exemption? Is it stacking and sampling when you come to the second proviso of sub-rule 7 of rule 10, please come. There is a process which has to be undertaken.
yes, ma'am.
Have you undertook that process?
But that is page 31, your Lordship, may kindly see.
Please, once that you have undertaken.
Page 31, ma'am.
Hmm.
This is what the exemption granted. Your Lordship may kindly see page 31.
Subject.
Yes. Exemption of stacking and sampling of license for person for transportation of limestone from Dungri limestone
That is
quarry.
true. That was granted.
That was granted.
Yes.
Your Lordship may kindly see the content of that, my lord. With reference to your letter dated so and so on the subject cited above, may be allowed for exemption for making stock or for
stacking.
transporting so and so, and they have referred to the rule, sub-rule 7 of rule 10 of ONTPS rules 2007, subject to following terms and conditions. The
You
lessee
will
shall
pay the
pay the
highest rate of
royalty,
royalty.
highest rate of royalty. Now, what is that highest rate of royalty?
It's a 90 rupees.
That is 90 rupees.
True. That
Yes.
is under that entry.
Yes, my lord. That is 90 rupees. Now, what the petitioner did, my lord? Petitioner went on paying 80 as per rupees 80. So the deputy director mines sought for a clarification from the director mines. That is at annexure 6, your lordship, may kindly see. Annexure 6. Now the director of mines clarified that it is rupees 80. Then immediately thereafter, when they realized that they have committed a mistake, they withdraw that. That withdrawal, although it is referred in the writ petition, but that has not been annexed to this document.
What withdrawal?
This annexure 6, which the director said that clarified that it is the highest rate of royalty is rupees 80. He clarified to the deputy director mines, that is at annexure 6, your lordship may kindly see, page 306. He clarified that when the deputy director mines asked that as for the exemption granted what is the highest rate of royalty that should be charged from the petitioner. Then it was clarified that it is rupees 80 by the director mines. If your lordship may kindly see page 306, said it is rupees 80 per ton, which may be treated as the highest rate of royalty. Now, this letter was subsequently withdrawn. That your lordship may kindly see the withdrawal. Although my learned friend has referred to that in the writ petition, but they have not enclosed this. If your lordship may kindly see.
That is the question of challenging the earlier writ petition, which is pending where the
Yes.
interim order was passed.
Lordship may kindly see.
Otherwise, yes, I have mentioned page 307, the interim order. Your lordships may just come to my readings, page 10.
Of the matters, you are there in that matter as well.
That was a previous matter, but I'll argue matter.
You give the brief of that matter. We are fixing both the matters from next Tuesday.
Well,
Dispose of the matter.
Yes.
well,
And so this interim order is creating. Where is the interim order? Like,
page
page
307.
Connection.
Annex 7. 309 is the order.
Your lordships will just come to the pleadings at page 10. Why that other writ application was filed was against that withdrawal itself, because without giving us an opportunity of hearing, they withdrew that, the concession of the 80 rupees flat. So that is the reason we came up before this honorable.
And without recording any reason, the blanket interim order is passed.
It was at the stage of admission, the notices were
So,
issued
no
and
other-
in
No
presence,
reason is required.
I will not.
No reason is required. The instant repetition is taken out by the
My lord, one thing to bring your lordship's attention, my lord. The committee observed at page 32 that the system of lottery was not fair. Basing
Was
upon not fair.
Where?
Yes, my lord. That's why it is cancelled.
Yes, same order, which matter? Item 12.
Man.
So that it will be list on the same day.
Man.
There is an order for cancellation.
Man.
The grievance of the petitioner in this application for us is twofold grounds. Firstly, grounds, only twofold. Firstly, grounds, the lordship will find even if there's adjudication is made under the Odisha Goods and Service Tax Act 2017, but substantial turnover pertains to VAT period prior to 1/7/2017. That is also the admission on the part of the first April authority before whom I have approached against the adjudication order. Now that matter touches the question of jurisdiction, because under section 1, subsection 3 of the OGS Act mirrors the provision of the Act mirrors section 1(3). Minus.
But 107 is there.
107 is there, but as my lords knows,
We have 10%, then be protected.
thing doesn't stop here. Mirrors, what has been done here from my electronic cash ledger, I am giving a small a half-page note. Your lordship will find 10 crore. Just a minute. 10 lakhs is the demand class. Mirrors, 1 lakh from what is the 10% which I have already paid for maintaining first appeal mirrors. Now, no,
Further 10%.
no, not only 10%, they have taken mirrors 8,70,000 from my cash ledger. If your lordship will find, I find this is a kind of atrocity, mirrors. Your state cannot take away money from my cash ledger. Cash ledger is mirrors an amount which is statutory ledger in which mirrors I kept my money. That is to utilize only to discharge my liability under the statute mirrors. It is not for the state mirrors to take away the money from my cash ledger and appropriate against the money which is not due mirrors. You rightly says, Order 112, subsection 8. Now that already there is a notification saying that if you pay 1,000, there is no tribunal. If I pay additional 10% overall what I have paid already, section 112(9) will operate with the remaining amount will stand state mirrors.
They will reward it back.
Exactly, they have to pay back. Your article Reliance judgment, my lord, under the RAMAN authority very recently, saying that if any payment in excess of that statutory deposit, it will refund it. Let them refund mirrors. That is so far as the refund aspect is concerned. But regarding jurisdiction, certainly I
understand. So let us decide it because the tribunal is not functional.
Correct.
So there is no difficulty on the part of the High Court to decide it.
Correct.
So, but there was some impression which was given on the last occasion that there
By September 28th.
possibility there is
Now latest information
would be put in place. So that is what is, if our judgment is to revert, they will have to revert.
No, Lordship, that is on different aspect. Your Lordship, let me clarify because this is a peculiar circumstances, Your Lordship. Here
They are passing a peculiar order.
Your Lordship, always.
How can it?
Your Lordship, what happened? That
CBIC
CBIC have issued a guideline. Your Lordship.
That if it complies a particular provisions, then in that event, there should not be any further action.
Let me clarify, Your Lordship. 2023, the first appeal order has been passed in 2023, Your Lordship. From 2023, Your Lordship is looking every day writ petition have been filed since tribunal is not there. Your Lordship, regarding the stay of the demand, Your Lordship, there was no earlier notification regarding the stay of demand. Let me, Your Lordship. Regarding limitation, Your Lordship, my Lord and Senior then closed the notification regarding limitation, Your Lordship. Once the tribunal has been constituted, from the constitution of the tribunal, within 3 months, the appeal is to be filed. But regarding stay, there was no notification. Let me, Your Lordship. Section 78 says that, Section 78 of the Act says that within 3 months, Your Lordship, he has to pay after passing of the order. If he has not paid within 3 months,
Now, your lordship, in the meantime. Then 7 also says that he has a remedy by law. Your lordship. And by virtue of this, if the limitation period has been extended, and it says that from the date of the constitution of the tribunal, he can file an appeal within 3 months. Your lordship. It is regarded as within the period of limitation. Your lordship. Then why not the court with excessive? Your lordship, may kindly look. Interim order. But the statute says the moment he deposits the 10%, the entire demand would remain in state. Your lordship, may kindly look into this notification. For the 10%. Then reward, what is the excess? Your lordship, may kindly look into this notification. This notification may kindly look into. Paragraph 3. Your lordship, this is the notification has been issued. Subject is that guidelines for recovery of outstanding dues in case wherein first appeal has been disposed of till appellate tribunal comes into operation, your lordship. Paragraph 3, your lordship, may kindly looked into from paragraph 3. In cases where first appellate authority has confirmed the demand issued by the adjudicating authority, partially or fully, the taxpayer cannot file appeal against the said appellate order at present due to non-confirmed operation of GST appellate tribunal. As per section 112, every person has a statutory remedy of appeal against the order passed by the first appellate authority or by revisional authority before the tribunal. As per section 78, the recovery proceeding are to be initiated if the amount payable as per the order issued under the said act and is not paid by the concerned person within the said period of 3 months from the date of service of the order. It may further be noted that if any person file appeal in accordance with the subsection 8 of 112, then the recovery of the proceeding balance amount is deemed state free disposal of the appeal. However, all the taxpayer are not able to file appeal under section 112 in the first appellate tribunal against the order of appellate authority, therefore are not able to make pre-deposit of 112A of CGST Act. In some cases, the taxpayer are taking a view there is no stay against the recovery under 112(9). In some cases, these are the. Now, your lordship, paragraph 4. In order to facilitate the taxpayer to make payment, the amount of pre-deposit as per subsection 8 of 112 of the Act and to avail the benefit of stay from the recovery of the remaining amount of confirmed demand as per subsection 9 of section 112. It is hereby clarified that in cases where the taxpayer decides to file an appeal against the order of the appellate authority and wants to make payment of the amount of pre-deposit 112A, he can make the payment an amount equal to amount of pre-deposit navigating from dashboard. The taxpayer would be navigated electronic liability register, which can select the order out of outstanding demand against which payment is intended. Now, paragraph 6. Now, paragraph 6 here. Paragraph 6 here. Your lordship, paragraph 6, your lordship.
Paragraph 5.
So,
paragraph 5, please.
The taxpayer also needs to
keep a copy with me.
Thank you. Taxpayer also needs to file an undertaking. Your lordship may kindly give them undertaking and declaration with the jurisdiction of proper officer. Undertaking for filing an appeal. If possible. Your lordship, appellate authority on providing said undertaking and on payment of an amount equal to the amount of pre-deposit as per the procedure mentioned in paragraph 4. The recovery of the remaining amount of confirmed demand as per the order of the appellate authority will stand state so and so 112. In case the taxpayer does not make the payment of the amount equal to the amount of pre-deposit and does not provide the undertaking declaration to the proper officer, then it will be presumed that taxpayer is not willing to file appeal against the order of the appellate authority. In such cases, recovery can be initiated as per the provision of law. Now, my respectful submission, let me complete, sir, please.
I have not
My respectful submission for your lordship is that here, the first appeal order has been completed on 29/11/2023. From 29/11/2023, he has never done any action, your lordship, never taken any action. So far as any undertaking, not deposited 10%. Let me complete, sir. Please.
No, I have not started. How can you make a reply? Have I started anything? I have not mentioned, I have not addressed my lords. It is my case.
You have completed the.
No, you cannot make a reply on your own. Sorry, sir. Extremely sorry. Sorry, sir. Because the notification which by Royal French Blessing Mirrors that is dated 11/7/2024 mirrors. Then the money which the department officers have taken from my cash ledger is 3/10/2024 mirrors. The second notification which my friend is placing mirrors, that says that in the event mirrors, I come up with my intention to file appeal because now there is no tribunal. And I make a deposit in the portal which is mentioned in paragraph 5 and make the payment. That 112 will apply and the remaining amount will stand state. There is no time limit for making deposit of this amount, even though Millards, my liability is only 10% which I have already paid and 10 more percent which I have to pay to maintain second appeal, pending constitution of the operationalization of the tribunal Millards. They have already taken on 3/10/2024 in two spells. Millards, about I have given a small statement to Lordship, 8,70,000. Meaning thereby, if your Lordship will deduct 10 plus 10, 20% Millards, they have already, and that is
Got your point, sir.
minus.
Does it mean there are two twin conditions?
Correct.
One is that you have to make a deposit of 10%, which you are saying that since the money has already been recorded, it will be deemed to have been deposited by you. But it should be followed by an undertaking which you have not given to them. So there are the twin conditions that shows that you have an intention to challenge the order of the appellate authority to the tribunal. You cannot take a shelter since they have recovered more than the 10% of the amount. So it will be deemed that you have complied the order.
I understand, Millards. I am ready to file an undertaking. Millards, that I will tell you. No.
Just wait. Let us see that what remedy can be given. If the statute has given a remedy. Now, question. This particular appellate authority had decided it in the year 2020. This notification came sometimes in the 11th of July 2024. Right? That means you have indicated in this particular notification that there has been a rampant case which is reported to the authorities that the authority is proceeding for recovery of the amount. Despite there is a remedy by way of an appeal before the tribunal. And even if they have decided to deposit the 10%, they are not going to seal the operation because there is no order of seal nor there is any facilities for deposit. So they were saying that this cannot be. If the statute saying that on deposit of 10%, automatic stay of the entire recovery, then in that event, why a remedy should be rendered cautious or redundant? The authority said that yes, in this scenario, if he deposits the 10%, signifies his intention that he intended to challenge the order of the appellate authority to tribunal. Then in that event, the deposit will be there and undertaking will also be filed. I will, the moment the constitution, the tribunal is constituted, I will prefer an appeal within the sentence. Now, the second, the catch which I that in the event there is a default clause, in the event they did not deposit, or in the event they did not file or do not file the appeal within the time frame after the constitution of the then there will not be any fetter on their part to proceed with the recovery of the after. The question is that it's doing in light much after the order of the at that point of time, this was not done. Now they have come up and they wanted to avail the benefits. Now the question is, will the High Court exercise its discretion in extending those, because these are the statutory rights.
Let's see.
I mean, visualize, these are the statutory rights. Why you did not frame it when the act was introduced? There was already a concept of a tribunal. Why it was not done?
I bow down.
Once they have, if there is no tribunal, they have a right to approach the High Court.
They have not approached. They have not approached.
Please, suppose if the tribunal is not there, quorum, if one person cannot be rendered forumless, there must be a remedy. There must be a quorum.
Only
if the right is created in the statute, then there must be a quorum to assert such right. If there is no tribunal, then the High Court can entertain an Article 226. If the High Court, then High Court has a discretion.
Undertaking, I have already filed. I am sorry, I am under instruction. Undertaking has already filed. This is acknowledged by the department, and the same is filed on 18/1/2024. 18/1/2024. My undertaking to file appeal has already been tendered before the authority.
But not deposited the 10%. Your Lordship.
Recovered.
What happened? Recovery is in 10th, Your Lordship.
Kindly visualize. Now situation. I am giving a.
No, Your Lordship, something error is there. Why? What is the error?
Let us see. You have assess the tax, say around 10 lakhs.
Yes. Your Lordship, in
In
appeal, it is
absence
17
of
lakh.
any better, have revised 10 lakhs.
Your Lordship.
Now he intends to file an appeal. Now you say, no, you deposit 1 lakh rupees more as a 10% of the 10 lakh.
No, not at all. Your Lordship. Yes.
Deposit. That means you are putting them out of pocket for 11 lakhs,
Correct.
more than the tax amount. What he's saying is that if the amount is already with you, which is more than the 10%, that why don't you deem or why don't you treat that particular deposit to have been deemed to have been made and then refund the rest of it.
Your Lordship, my respectful submission, the petitioner's argument is that he has given the undertaking in January 2024.
Much before.
Your Lordship, no, that cannot be. Because why?
See,
Why you Lordship? Why you?
I'm giving, just please see.
Why your Lordship?
You verify they are tomorrow.
Till your Lordship, the recovery has been made. Your Lordship, let me.
Please see by order.
The recovery.
Verify.
This is by order.
The recovery is
10th of what?
2024.
And this is undertaking is of January.
January 2024. He has not deposited that 10%. Only one undertaking has been given.
Whatever. The
10%.
1% only.
Your Lordship, how can it be, Your Lordship?
How can
Your Lordship, because he has not deposited, if this notification says,
Sir, fine.
Your Lordship.
You have not for approval. On the same day, you have allowed him to keep it in abeyance till certain things to happen. Unacceptable.
Your Lordship.
What is the purpose of unacceptable? Is that the purpose that you will not constitute a tribunal? You will recover entire.
I bought on that.
What is reflected in that particular notification?
Your Lordship.
You were conscious that this is what is happening and you find it that this is not proper. Then you give this particular modalities you adopted and to give a, I would say, the succor or to respite to those who wanted to challenge.
I bowed on that. Is absolutely right.
First three paragraphs you have to read. The authorities were conscious that this is what is happening.
Your Lordship, but
Absolutely.
Your Lordship, so far as
this relevant circular can be read into
Your Lordship.
2020 circular.
Your Lordship.
It goes back.
2020.
Relevant circular has to be read into this for 2020. It is in the nature of clarification.
My respectful submission is that so far as the reform, Your Lordship, so far as the
And
reform,
find out this undertaking whether it has been given.
that undertaking without any pre-deposit, Your Lordship, my respectful submission, he has not deposited.
Sir, will you read this notification carefully? Again.
Your Lordship,
6.
the paragraph 6, Your Lordship,
You use the word or.
does not make the payment of the equal amount of pre-deposit. Your Lordship, it's not, or does not provide the undertaking declaration proper officer, then it will be presumed the taxpayer is not willing to file appeal
That's offense.
against the order of competent
It
authority.
is disjunctive. Then or means a disjunctive, either of the situations.
So 10% need not be till tribunal is constituted. This is the manner in which I understand.
Your Lordship, may admit I will file count.
Whatever you do it, but there will be reversion.
Your Lordship, why my submission is so far as the reversal is concerned, I'm worried. Because in every dealer there will be multiple litigation will come to this honorable court. So far as the reform is concerned. Because in many cases,
I am asking you then who is responsible?
Your Lordship, Your Lordship knows very well, government
Who is responsible? Just give me.
Your Lordship, because so far as this refund is concerned, this is not only the case.
This is not only the case. There are plenty of cases, Your Lordship.
Then my friend will want, let there be no tribunal, and we will go and taking money.
I'm worried. I'm worried about.
It is prospective in nature or benevolent circular which operates. How do you close?
This 2020, this 2024 notification.
Yes. In the presence of 2020. In the presence of 2020 with particular reference to.
What I didn't know.
With particular reference to your circular.
Your Lordship.
Central goods and services tax, bracket.
No, what is this?
Ninth removal of difficulty.
This is something else. It is not an undertaking. What are you taking? Look at the tenet of the order. It's not an undertaking. We beg to state that we have preferred an appeal against the appropriate higher authority, against the order of the Joint Council of the State Tax Appeal with regard to the demand. Where you have filed an appeal? The language has to be. And we also, that is undertake you are seeking. We are undertake to submit a copy of the receipt of the concerned appeal. Where you have filed an appeal, sir?
That is at the stage of first appeal. 107 stage.
And the date is 18/1/24 because first appeal is the language I consider language is not appropriate because the undertaking is dated 24.
So my respectful submission.
First appeal order is 29/11/23.
My respectful submission.
First appeal order is 29/11/23.
True, sir. You have used the word against the order of the appellate authority. Give this copy. I think that would be more convenient to understand.
Instead of writing, we will prefer.
Please read the language, sir.
With due respect, humble submission, we beg to state we have preferred an appeal.
We have preferred an appeal.
We will prefer.
I do not know.
No, I understand.
Then read against
at appropriate higher authority, language against the order of the Joint Commission of State.
So it's an appellate authority.
Yes, I understand. This will
then again language.
With regard to the demand as mentioned in your above letter, we also undertake to submit a copy of the receipt of the concerned appeal at appropriate at an early date. That means I should have filed appeal, then I will give a copy. Then the language I understand. The language is inappropriate, absolutely inappropriate. But the intent of the letter is apparent.
My respectful submission, let him file appeal before.
Where is this letter of demand? You are not enclosed.
Letters must be pursuant to.
This is recovery of such letter 3695 CT 14/12/2023 after disposal of.
Yes, after disposal of appeal, but we will file appeal. He cannot write, we have preferred appeal. No.
Sir, recovery letter.
Your Lordship rightly points out.
You have written this letter in response to a recovery letter given to.
Correct.
That is 24/12/2020.
That what is my
My respectful submission. My respectful submission. My respectful submission before your Lordship.
Coming to High Court, he has approached the procedure till tribunal. That is what the purport of.
Your Lordship, what my respectful submission, let him file appeal before the tribunal, Your Lordship. Your Lordship, when the tribunal will constitute. And the balance.
The grandeur infrastructure.
Balance demand may be state because there is 70 lakhs demand. There is 70.
More than
Only Your Lordship, this has been done. Only this petition has been filed after the recovery.
Henceforth, we will direct the chairman of the tribunal to receive the appeal and to decide to do everything by himself. We are directing as per your request. Because the chairman has been reappointed, but there is no infrastructure, there is no supporting staff. We are directing the chairman himself to accept it and decide.
Your Lordship may admit
and write the order in his.
I may be permitted to file counter. So I have to take instruction from the department.
We'll pass the instruction. We are giving an opportunity. There is no fetter on the part of the court, not passing anything on. If the court finds there is a strong cover to the, at the very outset.
Let's see, no further recovery will be, let's see. But so far as the refund is, the refund, the
If the
refund
statute has fixed the limit, you can't go beyond. Sorry.
because from 2020,
Whatever, sir.
let's see, from
20% you are reduced to 10%. Isn't it?
let's see,
So why you have amended
from
the statute?
2020.
Why you have brought the provision that if we paid the 10%, all the further demand would remain still? Why that was brought?
Mm.
Then, if the statute gives them a protection merely because you wanted, no, I have already recovered, so he will be without any remedy.
Let's see, because from 2020 to 2024, there is no
Sir, there was-
notification regarding
Sir,
the
you were keeping silence, you were not giving them. From 2023, 2024, you have brought this clarificatory notification in the month of July 2020.
Yeah, let's see, from
So,
2020
Why
to
you waited
2024.
for such a long time? And the remedy. And still you are really postponing the limitation period. You are saying that the limitation will remain suspended. The moment the constitution, the tribunal is constituted, from that day, 3 months will be counted. Where the litigant will go?
Recently, GST Council has said each and every appeal is to be filed by June 2025 to 26. Recently. Yeah, let's see. I'll file counter deal.
Yes, but portion.
Yeah, let's see. That is the main prayer. Yeah, let's see. Yeah. Let's see, will allow it.
Yes, because VAT demand,
Yeah,
VAT
let's see.
period,
No, let's see, the prayer is the prayer to issue in nature of mandamus any other appropriate directing the opposite parties to quash the order, to issue writ in nature of mandamus any other directing the opposite to refund the amount collected recovered illegally.
consequential.
I'm going with the civil concern. If a suit solicitor for a permanent injunction is filed, does this mean that the temporary injunction to some extent cannot be granted? Court can try.
Yeah, let's see.
Item number 4, that
Document, I don't know.
No, this is not a time to mention. Why don't you come in the morning?
Madam, just my petition got withdrawn because erroneously is placed before single judge, my lord. So just in first half it was dismissed. So tomorrow is the schedule, so that's why I urge.
No, you go to the final appeal with the order is dismissed.
Is my withdrawn, I withdraw because erroneously it was placed before the.
No, we can't. Single judge matter is not mentioned before the revision. Go.
My lord, it's it should have been listed before the your lordship, my lord.
Why?
It was election petition transfer matter, my lord, and it was erroneously
Petition
listed.
does not come before us.
My lord, it is a transfer. I sought transfer. I am petitioning crossing, my lord, and I seek transfer from court number 16 to any other bench, my lord. It
You
is
can't. That's an administrative side. It's not a judicial side. You should know the procedure. It's not a judicial side.
item 4.
Yes, madam.
Let's see the.
Yes.
Yes. Yes. Item number 32, get for 2 p.m. hearing.
Remember, you actually asked us to submit the submission so that you also can look into it, so that the matter can be.
So it was not submitted.
No,
It
it's
was
submitted.
submitted.
We have all
submitted.
submitted.
It was not wasteful. This is all those.
That the good was made.
Yesterday it was.
It's come in the list.
Yes.
The submissions have been filed only in each case.
Now, 3 cases. Yes. 3 counted.
Yes.
And little record.
That is on the top of the list, in the cause list matter that is there looking.
What?
That written note of submission we have filed.
Was not.
Scan.
Yes,
that's
yes,
that's
yes.
that's
But in the cause list you can stand there.
We are not blaming you.
No, sir.
See where it is, where it is, my thing is.
In that event,
Yes. It's, what do you say?
Any other date?
that's the issue.
That's convenient to you, my lord.
That's correct.
It is not next week.
2 p.m.
Set all the sets to the respective. This is relation, in relation to a gradation.
Intercession
between
direct.
two direct recruitment.
Is not there in the state.
One is 2012-13 and 14-15.
Two
That,
advertise.
also remember that special drive, that our case is that special drive is contrary to the rules. So for us, the direct recruit, we are the direct recruits. On the honorable single judge, the judgment which you have referred to, that has not been taken into consideration, and the relevant provision of the statute has not been
Properly.
That is what possibly look to the.
Notes of the rules also.
Yes.
In my note, my note 1044, I have quoted the rules also. I have quoted the rules in the note of submission. I filed it as annexes.
In my
1044.
in my case, in my
The second
appeal,
is.
I have enclosed those rules.
We have also annexed it. I have given it in the one place, in the written note.
We are referring to 2 rules. One is 2010 rules.
And
The
another,
other one is ORV Act and the rules.
the other is 2016
16
rules.
rules. There are 2 rules,
Two rules.
governing the field.
Well, here the interest seniority between directee and promotee are also involved.
Yes.
So it's a common judgment passed in respect of 3 categories of people. 2 direct recruit batch and 1 promotee batch. So I
Why
am.
you are referring my judgment?
No, your lordship had said
My lord,
last time,
I agree.
the course of hearing, your lordship said that.
One of the Calcutta judgment is there.
It was fine.
That's subsequent. We subsequent that is my lord's judgment.
That
There is a judgment that came before I find with us, our judgment.
I see.
W.
Okay.
In
This
W.
is 1030.
No, one just.
No, I have referred to your lordship judgment.
I
Even
have
another
referred to your
judgment,
lordship
this division bench panel is also there.
This
This
is-
I have got judgment I am asking. No, that's because my lord, whatever grounds that was taken was never taken note of.
Very honorable Singh.
Well, I have referred to your lordship's judgment of this bench in passed in 2 WAs, where the scope and ambit of interference in a intra-court appeal your lordship have laid down. So for that purpose, I have enclosed 2 judgments delivered by this bench. In my written note of argument, I have submitted in WA number 1173 of 2025. WA number 1173 of 2025. There I have filed my written note of submission. I am appearing for the promotee group.
Give judgment of mine, you are referring.
In the calculator, no, the WA 941
See, the WA 941. No, that is not listed today.
No, I am referring to that. What your lordship is seeing, my lord.
That is in the list in which matter you have find a.
That is my lord 1030/2025.
I do not find any judgment.
No, judgment, my lord, is page 43 of my written note.
43.
Yes, please.
43 by us.
That your lordship is
So
judgment.
he's talking about a Calcutta judgment.
That judgment, you have given.
Yes.
That has been filed in your case.
In 1040, the calculated judgment I have. The judgment I have given a month.
It is a case of local judgment of the
So 1044 perhaps.
1044.
First, top. This.
Page.
Those judgments I have given up to Supreme Court, my lord.
No.
160. 160.
The question is what is the question is
1044 gala. Yes, ma'am. No, so.
My existing, you can see that. We have five, it's in spiral here, but you can see that.
No, which judgment of mine is referred. That's why I've.
see that you have accepted say that. There is doesn't put much here.
What do you know?
You have not annexed the judgment.
No point.
That is only.
This is the written note. The date chart.
No, I've given a separate bunch of judgments in the first data.
This is the written note.
Earlier to that, I have given a bunch of judgments. It is not there. I have given the first date in the court. 2 months.
This is our judgment.
The all the judgment I am relying upon, I have given a bunch.
But you have given the minor just
No, I have given a calculator another honorable judge, not of minors.
Is what you say.
Calculator judgment up to honorable, that is party name is my lord. Partha Sarath is same.
That is a single way.
After that, it has went up to honorable Supreme Court. One of the party has challenged it, Uttam Kumar Shah. Judicial service. The judicial service recruitment.
That I am aware of.
Yes.
Then ultimately no decision was taken by the Supreme Court.
Yes.
Yes, you give me a weekend.
Yeah, only thing, one more shot. The advertisement 8 of 12/13 is undergone there was another correction which could not be placed in record. I'm just making out an affidavit, so I'm filing it so that it may record at the time of advertisement. So this is just a correction to the advertisement. What happened, my lord? Initially, this ASO post was a Group C post, but correction was advertisement issued with as a Group C post. But subsequently, it has been changed to Group B post. That is why undisputed fact that was not in the last appeal.
Designation of the post.
Yes, only that is matter for, but let it on record. And I am filing 2 more judgments and giving.
The lordship is keeping to next law. Yet convenient to lordships, we have no objection. Or immediately after registration, urge your lordship matters.
Only Mr. Jain.
17th.
Mine.
Can I repeat, my lord? Since in the past case, all these written notes of submission by 2 the direct recruiters have been filed. I have filed my written note appearing for the promotee in WA number 1173 of 2020. I pray, my lord, let that be also taken into account while you not.
Things, when I said that I will go through all the written services.
Because it is in the another case.
That I will ignore any one of the.
No, not that. So I just
need not happen.
May I?
Obviously.
And I must be very candid that if a point is taken, whether the point is relevant or not, I always deal within my judge.
Yes, ma'am.
That's right.
That's yes, ma'am. Yes.
That is the only requirement.
That is the
Yes,
only.
ma'am. That is the basics.
May I say something? Just to identify, we filed 2 spiral written notes, one a short date stamping written note, and a spiral of all the judgments, which are there with all the paragraphs and everything noted. So just to identify, that's the written note from the opposite respondents side.
I am well accustomed with the system. Don't worry about it.
So because I do not know what scanning will happen. That may not be scanned,
No,
which is spiral.
And I must that I always go with the hard gas.
May I request my learned friend to give a copy, at least not scanned copy, at least so that we can exchange our yes.
Give a scanned copy to them.
My written note is exactly all the thing is really written, but I've seen. I haven't received one from them, so I was waiting.
To exchange.
Yes.
Okay. Yes, sir.
It's a reciprocal one.
That's it.
We have given.
We have given.
I have given.
My lord said exchange.
Yeah, we'll do that. That's what.
17.
Man.
2 p.m. 2 p.m. your lordship.
Yes.
Item 21.
Please, your lordship. I'm appearing through VC, my lords, on behalf of the department.
Not before I begin. Begin your lordships by kindly peruse your lordship's own order 22nd August 2025, which is an answer to the 25th August 2025, because they are raising the issue of maintainability.
Lordship, on the last occasion, 25th August.
Your lordships are recorded on 22nd about the maintainability on the very first day. Then subsequently, your lordships also recorded their observation, that is on 25th of August, regarding your lordship's maintainability when there is an alternative remedy. Now, my lords, what my submission, which your lordships have recorded on 22nd, I am a government agency, I am a government authority.
Let them, they have taken a preliminary objection. Let them first raise the preliminary objections.
And thereafter we will.
Lordships, Lordships may have that last order.
I have seen that. You have relied upon a judgment of
I
the
had
Supreme
para
Court.
90.
2020, volume 19, SCC page 681.
Lordships, I had placed para 19, the relevant
Paragraph 19. Give me that judgment.
It was handed over to the bench on the last occasion, my lords.
Must be there in the file. 2020, volume 19, SCC. Yes. Paragraph
19, my lords. I straight away, my lords, last occasion I had placed
90.
19, my lords, 19. That is at 704. Relevant page 704. Because this goes to the root of the maintainability, my lords, I'd asked them to respond to that. Lordships have para 19?
Yes, just cancel.
Lordships, may I place para 19?
Just 1 minute.
Yes, your lords.
Oh, this was the judgment which was cited. Oh, okay. Yes. Let's so. Yes, I got that.
Grateful, my lords.
Yes. So you wanted to say that since they have come beyond the statutory period of limitation, provided for an alternative remedy which is there, then in that event, the writ court should not interfere.
Lordships, that's the principle of prudence that has been laid down by the Honorable Court. That, my lords, if they have to knock on the doors of this Honorable Court, seeking the discretionary relief under the writ jurisdiction, they have to come within the limitation period.
I got it. The statutory period of appeal is there.
Is under section 84, my lords, is of 60 days, further condemnable by a period of another 30 days. So period of 90 days. The order was passed on 30th August 2024, and they have received sometime in October. They have come before this Honorable Court, filed a writ petition in the month of May. Defects have been removed and matter is listed in the month of August for the first time, my lords. Almost after a year after the order is passed. Correct. This is the prudence exhibited by the petitioner, my lords.
Correct. So let us see. These dates are undisputed. So let him respond to this.
The paragraph 90.
Well, I'll add one more, before you can say one more paragraph. There is no whisper in the petition, my lords, no pleading to the effect why they have approached this court after the limitation period is expired, my lords. The has been pleaded, no reason has been ascribed as why they have approached this court.
Understood. Let us see. Yes, sir.
Yeah. The 19 is the observation of the courts to the extent of saying that if there is a prescription in a statute regarding the limitation, then your lordships, while exercising 226 as an alternative remedy.
Yes.
So then in that case, whether the Honorable Court can extend that period, and therefore is it not a violation? It is nothing, no violation of fundamental right, no violation of the statutory right of me for what I am asking at the approach this Honorable Court. This is the limited point. Now, your lordships may kindly see my written note for a moment. I have given a comparative chart. The paragraph number B. Unless there is a clear legislative embargo through negative fetter on limitation, such as not thereafter or not later than, as opposed to the positive expression of further period, exercising Article 226 after further period, will not infract the Section 85 of the Finance Act, which I am invoked. They are asking me to go for an alternative remedy, an issue which only this Honorable Court can settle in the present facts in law, involving these two different legislative policies. So what I am distinguishing the paragraph 19, in that particular the judgment is rendered under Section 91, Section 31 of the Andhra Pradesh VAT Act of 2005, where it has stated a timeline of 3 months and then thereafter further period for the appellate authority for 1 month, which I have given in the comparative table at the page number, the page number 7. I've just given a comparative table. Extreme left top, that is actually the Glaxo. That was actually there by the Glaxo. Provided, the second provider, the first provider, provided that appellate authority may, within further period of 30 days, admit the appeal preferred after 30 days if he is satisfied that the VAT order or any other dealer had sufficient cause for not referring within that period. So that's a legislative mandate so far as the assessee is concerned, for which a 30 days is given. That's a quote unquote the sufficient cause and further period. These are the two expressions used. And that's what the Glasso law has dealt with it. Now, my lords, my submission, if your lords will see our provision, that is section 85 for a moment. Kindly go down a little further, my lords. Section 85. I have also quoted that. I am covered under the section subsection 3A, the bottom of the second box. Provided that CCE appeal made, if he is satisfied that appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 2 months. Here, my lords, the expression used is that presentation of appeal before the appellate authority, further period and sufficient cause. So therefore, if my submission to that effect, Lord, your lordship may kind, and then Lord, your lordship will see the right-hand side column, left-hand side I have designed in such a manner that only the further period is shown to my lord, as opposed to the legislative policy of the not thereafter. That's the section Order 8 Rule 1. That's the lord's Order 8.1, right-hand side top, where it says, provided that where the defendant fails to file the written statement within so and so 30 days, he shall be allowed to file, shall not be later than 90 days from the date of the service. So there is a two different principles. That's also the principle of section 34 of the Arbitration Act. So there are two different class of legislative policies so far as the limitation is concerned. Now the Glaxo dealt with the further period, appellate authority instruction, and then sufficient cause. Now I am following in the section 85. Now here, my written note for a moment. Your lordship, just kindly have a look at my written note for a moment. Then subsection 2. Now, the Glaxo law says that when the provision of the law is creating a right in favor of a party and he is not availing that right, there is no breach of that right, statutory right. Then I cannot invoke 226 because 226 has two enforcement. One is a fundamental right enforcement. One is a statutory right enforcement. Now, whether this section 85 subsection 3A proviso regarding the further period is a right to be or not, that's a proposition which I am trying to frame for my lord's consideration, that when you are the assessee, one of the litigant with me as an assessee, I mean as a taxing authority, and a legislation is prescribed for you, where one portion of the law says that if beyond a particular time I do not come, does it create a statutory fetter on me for the purpose of the exercising the jurisdiction of 226? That's the limited point. And therefore, my humble submission to this respect, in this regard, in the scheme of the VAT Act that the Glaxo dealt with, that's the first instance, my lords. Let me also inform you this on the court. This 2020 judgment of the Honorable Supreme Court has dealt with this issue for the first time, so far as the further time is concerned, on a scale of if a statute gives a non-existent right, and that right I am not invoking, then it is a substantive law and it is not a procedural law as opposed to the CPC. My case, what I am trying to nuance here, that whether the exercise of 226, where a right is given to me for the first time by a statute, and I am not invoking that right, then whether my lord will exercise and extend that right. Here talking about the adjudicatory process of a redressal.
What is the distinction? When you try to make a distinction, the right accrued for the first time and the right which is already there, can there be a distinction or can there be a differentiation in between those rights? The question is, there is a statutory right by way of a remedy provided to a litigant. I am conscious that so far as the Article 226 powers are concerned, it is not hindered by any kind of, the obstacles, including the existence of an alternative remedy by way of an appeal. The writ court may entertain the writ petition despite the alternative remedy being available to it. But there has been a check and balances which are there since is of 1954, if I correctly remember.
Yes.
So it says that yes, definitely the writ can be entertained, but there are certain restrictions that you should not entertain in this regard. Now, this is the first time a departure I find in 2020 judgment, where it says that yes, you can invoke the writ remedy, but if there is a prescribed period of limitation provided in the statute for a statutory remedy, then the writ court should be moved within that period of limitation. Now, what has come up from this judgment is that there has been certain more restrictions imposed in entertaining the writ petition. Now, you have to argue that whether these principles which has been laid down is binding on us, or there is another judgment of a higher quorum or a larger quorum prevalent in the legal parlance.
Yes.
You are taking clue from Order 8, Rule 1. That was, amendment was brought in 2002. I am conscious of Kailas versus Nanku of Justice S.B. Sinha's judgment. I am conscious of subsequent judgment, even a Salem Bar, where it says it is directory in nature and not mandatory. It talks about that in an exceptional and extraordinary cases, one can definitely enlarge the scope. Kailas versus Nanku was a very special case. In that case, the gentleman was coming on 90th day in the auto, met with an accident and was hospitalized. He could not file the written statement within 90 days. Then the question arose whether the court can. Even a section 148 was taken into account by the court, CPC, where the enlargement of time can be also given if it is any time limit is provided. So the court says that in an extraordinary, exceptional circumstances, there is no fetter on the part of the court to extend the time. It is directory in nature and not mandatory. But the reverse is also true when the Commercial Courts Act is introduced. CPC has been amended to suit the Commercial Courts Act. There, the Supreme Court, in many judgments, have said time limit for filing the written statement is mandatory.
Correct.
And the court, after the outer cap fixed therein, cannot extend the time. These are the questions where the power is exercised by the appellate authority or the court. Whether such notion would still apply to a writ court is the larger question.
The test is the answer lies in the same judgment, and your lordships asked the first question whether the judgment has any binding precedent and whether it is binding on your lordships as a fifth ground not to entertain a self-imposed restriction by the 226. But the answer lies within the judgment. I'll drive your lordships to those the paragraph to show to this Honorable Court below. While the paragraph 19 says that the court should not entertain after the timeline, the court also examined at the paragraph 23 to the extent of the absence of this party, which is an assessee. My lord, while we are examining on all these points, one thing we must, I request your lordships keep in mind. I'm an exempted government authority, never taxed. I'm not registered, I'm not an assessee. All the judgments, my lords, whether it is, my lords, the Glaxo, all the judgments referred in this Glaxo cases, they're all with respect to the assessee. This is the only case where
Sir, the question is that when a person comes within the purview of or a definition of an SSA, now if the action of the authority is assayed, where such action was contemplated or initiated, treating a particular entity as an SSC, it may be a defense of that entity that I am not an SSC. That is the matter to be decided by an hierarchical system of adjudication provided in the statute or in the constitution. But you can't, since you perceived yourself to be not an SSC, Whereas all the orders are binding on you as of now unless set aside. Termed you as an SSC. Can that principles go at this stage?
And then my argument is this to that extent. First of all, I have to meet the limitation where your lordships can access.
The only question which now troubles is that first thing is that can there be the restraint? Can there be any obstacle? Can there be any hurdle created in entertaining the writ petition on such parameter as contemplated in paragraph 19? I am simply asking whether this judgment has a binding efficacy on the court, or it is in departure to the earlier judgments or the judgments of the same court.
The court has come to this conclusion on the premise and examination. There are two things. One is a premise and one is examination. And it has not said anywhere that the court is bounded by this limitation of the provision of the limitation. Nowhere says. It only says an observation at the paragraph 19 in the facts of this particular case, where the court has also gone into the extent of examining paragraph 23 of that fact. Where in that case, Swaraj, what happened? More than 1 year he has come. He actually filed the review petition. He was an SSC. He was filed the review petition. It was dismissed. He filed an appeal. It was dismissed. He did not challenge the appeal. He did not challenge the review. He challenged the main assessment order, which is after more than 1 year. That's exactly what has been discussed at the 23. If a lordship may kindly see that paragraph number 23 for a moment. Arguendo, the lordship may kindly. Arguendo, reverting to the factual matrix of the present case, it is noticed that the respondent had asserted that it was not aware about the passing of the assessment order 21 June 2017, although it is admitted that the same was served on the authorized representative of the respondent on 22 June 2017. The date on which the respondent became aware about the order is not expressly stated either in the application for continuation delay filed before the appellate authority, the affidavit filed in support of this application, or for that matter, in the memo of a writ petition. On the other hand, it is seen that the amount equivalent to 12.5% of the tax amount came to be deposited on 12th of September 2017 after more than 2 months and on behalf of the respondent without filing an appeal and without any demur after the expiry of the statutory period of maximum 60 days prescribed under section 31 of the 2005 Act. Not only that, the respondent filed a formal application under Rule 60 2005 rules on 8th of May 2018 and pursued the same, which was rejected on 17th of August 2018, more than a year now. Furthermore, the appeal in question against the assessment order came to be filed only on 24th of September 2018 without disclosing the date on which the respondent in fact became aware about the existence of the assessment order dated 21st of June 2017. On the other hand, in the affidavit of Mr. Sridhar Raut, site director of the respondent company, filed in support of the application of a continuation delay, it is stated that the company became aware about the irregularities committed by its erring official in the month of July 2018, which presupposes that the respondent must have become aware about the assessment order at least in July 2018. In the same affidavit, it is asserted that the respondent company was not aware about the assessment order as it was not brought to its notice by the employee concerned due to his negligence. The respondent in the writ petition was averred that the appeal was rejected by the appellate authority on the ground that it had no power to condone the delay beyond 30 days, when in fact the order examines the cause set out the respondent and concludes that the same was unsubstantiated by the respondent. That finding has not been examined by the High Court in the impugned judgment and order at all, but the High Court was more impressed by the fact that the respondent was in a position to offer some explanation about the discrepancies in respect of the volume of turnover and that the respondent had already deposited 12.5% of the additional amount in terms of the previous order passed by it. The reason can have no bearing on the justification of non-filing of the appeal within the statutory period. Notably, the respondent had relied upon the affidavit of the site director and no affidavit of the employee concerned, or at least the other employee who was associated with the erring employee during the relevant period has been filed in support of the stand taken in the application for continuation delay. Pertinently, no finding has been recorded by the High Court that it was a case of violation of principle of natural justice and non-compliance of the statutory requirement in any manner, be that as it may be, since the statutory period specified in the filing appeal expired long back in August 2017 itself, and the appeal came to be filed by the respondent only on so and so without substantiating the plea about inability to file appeal within the prescribed time. Now, that's the important one. Without substantiating the plea about inability to file appeal within the prescribed time, no negligence could be shown to be respondent at all. Then, now, my lords, while this particular observation has come, your lordships may just see this for a moment. The paragraph number.
I don't see how it helps him, my lords.
Then, your lordships may see the exceptions, the paragraph number. (15) for a moment.
Yes.
Paragraph number 15. Well, in the Titaghar paper bills, the Honorable Court, while holding that where the statute creates a right or liability, providing for a remedy for enforcing it, then the statutory remedy must only be availed of. That's the scheme of this particular the judgment of Titaghar. What I am submitting to that respect, that when a provision of law which is prescribing a substantive right for the first time, and I am asking through 226, not through the statutory process, then the court will be bound by that particular substantive right. That means after that period, I don't have any right exist. Now, my submission to that respect, our case is that the right which prescribes section 85 regarding the appeal, it is not a right per se. It is part of a procedure. Section 85, subsection 3A, and the provision. It is not a right per se because after all, there are two litigants. Me is one litigant and one is the SSC, the department. And the department is abusing the law, violating section 93. Therefore, this pass an order. And then I am being asked to say that if I do not come to that particular court, that statutory forum, then I cannot come to the Honorable High Court, and the Honorable High Court will not exercise that power for enforcement of my right, which has been arrogated to a statute. Because, my lords, the property which the state is demanding through an assessment order is not the state's property. It's through a statutory process, you are creating a non-existent right in your favor. Now, if that order I am aggrieved of, and I am challenging that order, then whether the Honorable Court will be guided by the paragraph number 19 of the Glaxo, where it says that beyond that 3 months and 1 month, and in this case, there are 2 months and 1 month. Paragraph number 3 here.
So whatever we are not concerned with the quantification of the thing. We are more concerned with the inhibition, with the obstructions, with the restrictions imposed by the Supreme Court in that judgment. Now question is whether outer limit is a 60 days or outer limit is a 90 days or 120 days or 160 days is immaterial. Question is that once the writ petition came to be filed beyond the outer limit,
right,
then in that event, the rule, the paragraph 19, the observation of the apex court is that the court should not entertain the writ petition and should relegate the parties back to the forum where they want to exhaust their remedy or explore the possibility of their remedy. So this is what is contemplated therein. And the ratio of the judgment is to be culled out. It is not one minuscule difference in the facts, because there cannot be two facts. There cannot be two judgments on the similar facts. Can't be.
I am distinguishing that judgment.
So that is what I simply wanted to know from you. That this observations, you have cited that this observation came in the light of the facts which was there.
Correct. And the position of law in that.
Not a position of law is a different one, yes. Anyhow. And secondly, you say that the writ courts is restricted only to two situations. One is when there is a fundamental rights, there cannot be any restrictions.
Violation of
It is unvetted, or in case of any infraction of the
law
statutory rights.
and then the principle of natural justice.
That is coming from the constitutional rights.
But they treat it as separate law.
It is not treated. It is one of the basic tenet, tenet of the fundamental principles.
And then the virus challenge.
And then the virus is also again constitutional one.
Yes, yes.
The third category is when there is any contractual disputes also, which should come
Private
within the
dispute.
purview of. So this is the writ jurisdictions are there. I am conscious that so if the infringement of fundamental rights are there,
Yes, Lord.
then there cannot be any limitations.
Correct.
Nor the delay and laches can be a ground for rejection of that particular writ petitions. Cannot. It's a violation of the fundamental rights.
Jurisdiction aspect.
But
Jurisdiction.
what jurisdiction? Jurisdiction it has. The 19 does not talk about the jurisdiction. There is a distinction between a maintainability of the proceeding and entertainability of the proceeding. When you talk about the jurisdiction, it impinges on the maintainability.
It was not.
The court cannot maintain it. There is no jurisdiction to maintain this proceeding. One is maintainability is there, but the court may not entertain it. The question is entertainability. It says that the writ is maintainable. It never says that not maintainable.
Absolutely.
But the writ court should not entertain this writ petition. Why it should not entertain? Because you have approached the court beyond the outer cap fix for filing an appeal, and by passing that provision, you cannot achieve something indirectly which you cannot achieve directly.
Therefore, the violation of the section 93, the exemption, which now I'll go through the order. There is a principle of natural justice violation, number one. There is also.
What is the natural justice? The violation?
Well, that's the violation.
Whether you were given an adequate opportunity of hearing.
That's what I'm saying.
Whether you were given all the papers which they have relied upon, everything has been given
it's not
there.
Done. If you
What are you saying?
my lord, your lordship will get into the order, the challenge order, my lord, the impugned order. Your lordship see the paragraph number 17. My jurisdiction is not answered because I'm actually asking your jurisdiction. How do you exercise? Because 73 only gives the authority to quantify the determination of the amount of the tax. If your lordship will see the section 73 for a moment, the kind of a jurisdiction these statutory authorities given being a special body notes to compute, they have only given the power for determination of the tax not paid, tax higher paid, tax avoided, or refund is taken more, or in the GST below the input tax credit is availed. The detail
all this, but here is a question whether on the face of the fact which is undisputed, writ petition is entertainable or should be thrown at the first without entering into the fact.
My Now,
straight away, the point is very simple. We wanted an answer from you that whether this particular notion or the ratio of the judgment has any binding efficacy or is it a binding precedent, or there are other judgments which were unnoticed in the instant judgment, which says otherwise.
Because I'll try to find out to assist your lordship.
This is the first and foremost thing one should come when a judgment is placed.
But according to my,
I may respond, my lords. One aspect.
You should not.
My lords.
We are in the process.
I'm sorry.
I found out from my research, so whatever the detailed research I have carried out, I've seen that the one of the component of this no, they are, well, I'll tell you. AR Antule, that is actually the extraction of the ONGC case that is regarding the Article 142 scope. That AR Antule and then the Union Carbide 1991 and then the Advocates Supreme Court Bar Association judgment of 2007, which is quoted in the ONGC case. The ONGC case is what the party wanted is that because you could not have, because the Honorable Court formed an opinion on this aspect, a limitation, they were urging the court to exercise the power of 142.
Oh, I am conscious, sir. So far as the observations or the portion of the judgment which comes in exercise of 142 under Article 142, 19 is the declaration of law under Article 141. So now it is binding on the High Court. There is no further to that. Now question is again,
I'll answer that.
You have not made a correct research.
I followed, Lord. I'll tell you, before I conclude, Lord, with a...
You have been grappling with one notion, I being not an SSC, how can I be put into a jurisdiction? You are saying that if I am not an SSC, you cannot exercise jurisdiction. These are essentially mixed question of fact and law.
Correct.
It's a mixed question of fact and law, which requires to be determined on merit. But once there is some obstacle is created, unless you remove that hurdle, we will not enter into that arena. We wanted this first.
Would you lordships like to see the one paragraph of this particular judgment where they say that you should not use it as a matter of course? So does it, to my mind, my lord, what I have understood that particular judgment, because it's on one way it says that the beyond timeline, because the limitation that the court will not exercise that power. That's one. Also on the same judgment, my lord, he has stated that it should not be entertained as a matter of course. Now, what I am submitting to this Honorable Court as an exception, that beyond timeline, your lordships can still exercise the power.
Show us the judgment where I can exercise the power, writ jurisdiction, writ powers. Show us.
No, then please see the flip side of it. Please see the flip side of it. I have actually approached them under section 85(1) because after I received the order dated that 30th of August, I received it on the 18th of October. But with a defective order, which is a 4 pages missing, which is also it's missing here. So therefore, the order, according to me, my lord, this is not a complete order. Therefore, the limitation would not start. That's one part of the argument. Then, despite that, I challenged it. My lord, I filed it the 2nd of January 2025.
That would be your first defense.
That's my first defense. I know. No, lordship.
If the limitation period does
still
not
there.
reckon,
Correct.
then the question of principles does not arise.
Correct.
Because it talks about a limitation.
I just thought of not
Then show us show us the judgment that the limitation does not reckon.
I'll do one thing, my lord.
Does not reckon. If the complete set of orders is not communicated to you, the
Limitation
right of appeal becomes in limbo.
Correct.
And will only start after
receipt of the
complete copy of the order.
Correct. No, that's
second thing is, did you approach the authority to ask for a complete set of orders?
Yes, my lords. I gave it a copy. I requested
that
them.
also to be shown was the judgment that the limitation does not start from
there. Well, these are the two propositions I am leaving with.
No, the first point is valid one which you are taking. If the limitation does not take in, question of invoking this paragraph 19 does not arise. There is no quarrel in our mind or no ambiguity.
Absolutely.
It only applies when the limit starts.
I was only I was more concerned that if I can, because this is the judgment, particularly this 2020 judgment. I'll tell you, it is actually creating a lot of problematic. It's a problematic in many ways. And the same judgment, that's why I have given a schematic table for my lords. If your lords will see the Glaxo at page number 5 and 6, I've given the entire judgment to the one page in a schematic form with a color scheme to show to this Honorable Court how they are interlinked and how it is confusing. And to the extent of the
CNV.
No, on the conspectus.
Again, I am saying, can we go into that aspect?
I will assist.
This judgment is ambiguous. This judgment is not correct. This judgment is.
Your lordships knows this is a judgment binding on the parties so far as 141 is concerned with respect to the lease before it.
No, sir. If it is the ratio of law, it binds.
Sir, at all.
I am conscious of the judgment of the Supreme Court. If a particular ratio of law is decided in one case, and subsequent thereto, the Supreme Court of the larger CORAM says that the principle of law decided in that case is not a correct principle.
But I will distinguish some facts.
But again, I'm saying the ratio may not be binding, but the ultimate decision which has been taken is the binding between the parties. Even if the subsequent judgment says that not overruled, says that the principle of law is not a good law.
Correct. That's 141.
No. So that is why here also, you can't term it in that sense. It is a ratio which has to be taken into account. Now, ratio is to be culled out from the context. And it is not an obiter in that sense that the one should ignore. Even the obiter at times is binding on the court nowadays.
Absolutely. I agree with that. I want to show to my lords under the distinction and facts and the distinction of the law they're not taking note of because that's under the Andhra Pradesh VAT Act. That's under the VAT, and that's a different scheme.
Sir, in both the languages are there. If one can reasonably find the outer cap having put, then there cannot be any other aspect.
Would your lordship would like to see the section 73 subsection 2 for a moment?
Please look at it. If there is no power provided or granted to appellate authority to extend the period of limitation from a particular point, then in that event it has to be regarded as the mandatory.
My lord, if your lordships agree with me on one proposition that every statute has a perimeter of its own, and that has to be drawn from out of the language of the statute. Every statute has its own jurisdiction, and therefore I say that if at all we can draw the perimeter of that statute, and the authorities acting under the statute is drawing extrapolating and intrapolating the perimeter of the statute, does it prevent the 226 follows to say that no, you have extended the perimeter and then by virtue of exercising a statutory power, you are actually elongating?
asking you one question. If you would have filed an appeal on the day when you filed the application, whether the appellate authority had a jurisdiction and power to condone the delay?
No, it cannot.
Question. The matter is closed there.
Correct. Therefore,
then Article 96, paragraph 19 comes.
No. Therefore, I say there are two things.
That's the first point you show me.
I'll meet that.
Necessarily, this kind of the discussion would not, would not invite any meaningful, please show me the first advent that the limitation does not start unless the full text.
That I'll come back with that. But the only thing that, not apart from that's on the factual metrics, that's actually, that will also stand on the factual metrics, the proposition to the law.
You may not be a necessity, it has to be. They determined, and if the court determined,
No, this is a
all these
recipe.
judgments has to go, but
Like, to my research, what I have done till now, I have found out this is a proposition which is remaining res integra, not even this in that 2020 Glaxo case. The issue is whether an SSC, which is a non-SSC, a jurisdiction is exercised, whether this judgment to the effect of the jurisdiction would lie, and if at all, then whether the limitation would create a fetter on the exercise on the entertainability of the Your Lordship's jurisdiction. That's a proposition yet to be answered now. Your Lordships can delve into that particular proposition. So I'll guide Your Lordships on that, at least on the conspectus written note. I'll come back to that.
look at the law, come back.
I'll only look at the
law, I'll come back.
Yes, I'll come back. Kindly give me a short tape on the Lordships.
Whatever time you want.
Next week.
The law, you are proposing certain principles to such a great height, ponder upon this thing.
That's why I was trying, because I didn't get till now.
I am conscious on the jurisdictional points, but it has to understand that whether these points can be projected to avoid this statutory remedy, and the appellate court not decide that particular would have decided.
Look at it, the flip side.
Then what are the jurisdiction? What are the jurisdiction exercised by the authorities? One is in relation to a territory, is a territorial jurisdiction. One, that is in the civil cases, it's a pecuniary jurisdiction. In your case, it is not. There is no restrictions on the pecuniary basis. He can. And the third one is the plenary jurisdiction or inherent jurisdiction. And the fourth one, as in your case only, is a statutory jurisdiction. Now the question is that once in the territorial jurisdiction or a plenary jurisdiction, I mean the inherent jurisdiction. Inherent jurisdiction means in relation to a subject matter of the proceeding. So he had the jurisdiction to declare any person as an SSC. The person may thrive that I am not an SSC, but the authority has a jurisdiction to declare any person as an SSC.
That is through a statutory process.
And again say, is this, if he has the jurisdiction to hold that you are an SSC, then can you say it's a jurisdictional point? Because then you have to go in a higher forum, and then say that I have been wrongly roped in as an SSC. I am not an SSC. So
answer lies in section 68 and 69.
It's a mixed question of fact and law, and we will not entertain. Come ready, unnecessarily. We should not just beat the bush.
But the section 68 and 69 perhaps is answers my lord's the apprehension. It says that if somebody who is actually the SSC, it's a self-assessment procedure. It's not like authority will arrogate the power on its own. It has to be only through a procedure. That's why I'm saying that. Act and rules.
The wrong assumption of the jurisdiction is also essential.
And kindly permit me, my lords, to file an affidavit to that effect. And the documents, all documents. All the documents and the affidavit which I have not filed it, I'll file that in the next time.
Yes. Next week.
Item 22.
Next week is a particular date, Lord, so that I'll be in a position to come back.
18th. On 18th.
Beautiful, my lords.
Item 22.
The item 22 is actually a little different, though the language is the same so far as the incidence is concerned, the identical language. But actually, this is in the CAMPA, which is a statutory demand made by the CAMPA Fund Authority, and that amount of 200 crore which I paid it, and then on that they have invoked this demand, which in any case, admittedly, I'm an exempted entity. Therefore, the RCM operates. So I am already regulated through RCM. By invoking the same notification, that notification which they are invoking against me, even though that notification gives me the exemption power, exemption status.
Yes.
So therefore, I am any case as well. This is a case where little on a higher scale than the earlier matter 21, where I am saying that this is a statutory demand. Statutory demand, you cannot demand it. Now, whether on that, well, the limitation again will come as it was there in the earlier one. It is slightly different from the 21 item. It's a purely legal question. There is no facts, no figures, nothing. It's a pure question of law. And whether that jurisdiction of GST Act will apply when it has already exempted me under the same notification which they are invoking against me for this particular demand.
Yes.
So therefore, if you also will see the notification for a moment.
Unlock your iPhone.
Just a moment, my iPad. So it'll hang it now. Okay. The notices will not improve. Improved order not starts from
Page 10. The actual portion is
now here the relevant portion of the notice
the single
Lawsuit first of all, the ground of limitation. Ground of limitation.
I am asking, is it a single notice? One so-called notice?
Earlier notice has been issued. Earlier notice has been issued and they have also replied. Lawsuit.
I mean the single so-called notice covering the multiple periods.
No.
So you have asked for from 2017 onwards.
It's period of multiple period. Single so-called.
Malone, kindly turn to the page number 38 for a moment.
Lordship, the similar to that earlier matter at a round of limitation first.
Which you have started.
It's
Actually there are
the
multiple
same
period because this amount was the amount was given over a period of time for all the expansion of the roads. This is all the forest area which was converted for a non-forest area. So for environmental clearance.
When the original order, this is what
The original
order.
Yes, but the relevant page is 38 for a moment.
What is the date of?
The date of the order 31st of December 2024.
You have filed the writ.
I filed it on the 3rd of June.
That means 6 months.
Okay, 5 months, not 5 months. And I have received the order copy on the 14th of January, 14th January.
In January.
Correct. When I filed also the appeal, they said that you first pay it the 10% which is running into 10 crore. Because this amount of 210 crore.
You already filed an appeal.
I filed the appeal. They did not receive the appeal because they demanded the section 107 subsection.
But does it put a fetter in filing in accepting the appeal? They can say it's a premature document.
No appeal shall be filed under subsection 1 unless it is paid. Subsection 6.
The subsection 6, I have a basis.
Yes. So therefore, since I did not deposit the amount, so they returned it. I mean, they did not give me the acknowledgement. It is still lying with them, but they did not acknowledge it. So thereafter, I came to this on court only on the pure question of the jurisdiction, because the 2017 to 2020, there are 3 years period for that entire amount of money that is deposited in the Campa fund, 205 crore. They have demanded, and 35 crore is they are demanding, and double the amount which because they were to justify 5-year period that fraud. Therefore, they had to also demand the penal amount to the equal matching assessment amount, which is now roughly standing about 80 CR.
Section 50.
Section 50, yes, Lord. That's a matching amount, because they are saying that if you are for ABC, the fraud or misstatement, etc., then you have to pay also the penalty, not like you have missed out or something. So therefore, the paragraph page number 38 is very relevant, bro. They are invoking a notification against me to justify it. That is the notification which actually gave me the exemption. Therefore, I am not chargeable to any service GST. The page number 38. And they have not answered that question.
Yes.
The page number 38, if you'll also see the notification number 11, 2017,
Yes.
which is this is a notification of exemption. The central government has issued this notification in the consultation of the GST Council. What they have stated is the serial number 35 and the chapter section what they have stated that this is the notification where, if at all I am a government authority and I am availing as supply lots, I am availing the supply, then the reverse charge mechanism will apply. The person who is contractor who is actually serving me, he will only pay the amount. So therefore, this is what the bottom of the 7.10, the liability to pay GST in respect of such services, that is toleration of an act or any other services provided by the government, except where specifically excluded, has always been on the business entity receiving the service, that is under reverse charge mechanism. What I am submitting before my lord is this. This is the notification which was invoked against me, exempting me. And the service that I availed, a reverse charge mechanism was applied to the contractor, and the contractor paid that GST. But just because the contractor is now changed to the government, statutory authority now is the Campa fund, and I paid that amount of money because I was paying the amount of money to the contractor. So contractor was accessible to GST on a reverse charge mechanism. But here, just because the contractor's position is changed to the Campa fund, that is a government authority, is exempted. This is because of this particular notification on one hand. Now they are invoking against me the very notification which allowed me to go through a RCM. Now actually is being used against me just because the other authority, that other person is not a private individual, it's a government statutory authority. So therefore, the moot question, my lord, whether the supply as defined under section 7, a choice which I will invoke, then only the incidence of liability will accrue. Whether will fasten on a statutory exaction of the nature of Campa fund. Now, for example, if the income tax is an exaction, whether on the income tax amount, the GST would accrue. Similarly, Campa fund and the exaction, whether the Campa fund also the GST would accrue. It's a very extraordinary, it's a substantial, profound questions. and A, and B, a very notification whose benefit of RCM was given to me, therefore I am not accessible to GST tax levy. Can the same notification is used against me for a levy? That's a question of law, pure question of law. And that too over a period of 3 years. Now, every year, that every road across India is being constructed by us on the mandate of the Constitution of the Government of India. And then the NPV that is given to the authority, which is somewhere, sometimes it runs into thousands of crores of rupees. Now, they never taxed even a 1 penny against me because of this notification. All of a sudden, the same notification is fastened on me. Now, can this be countenanced? And now, can we then say that the limitation is there? The section 104 says 3 months and 1 month. Am I really less? And the court 226, well, your lordships perhaps will develop, at least now this is a multiple litigations now coming in. Imagine a situation, somebody who is actually outside the jurisdiction will just maliciously prosecute somebody, and then you say that go through, and if the person is not...
No, sir. No, sir. And this is a very concern.
I agree, my lord. I'll withdraw that word, my lord. I'll not use it for a moment.
Because that requires a lot of wrong beliefs in that.
Correct, lord. I agree with that. I agree with that. I'll not get into, for example, not the abuse of the law. For example, I may argue, my lord, the abuse of the law.
Is the illegal assumption of the jurisdiction or improper assumption of the jurisdiction. That is what is something, again, I say, is essentially a mixed question. Because once the jurisdiction is exercised, the High Court has to say you have no jurisdiction.
Whirlpool says...
Oh, so next question.
Unquestionably, it's a basic structure. Your lordships are El Chandra, and it will never be questioned. Now, whether by invoking 245 to 46.
You are talking that, then I am inviting your attention that can you cite a judgment?
Yes,
which is of a larger forum.
I'll come back to that. Correct. Yes, I'll help. That's what I was saying.
If you need, but you still do not.
No, I'll come back with that. I have given the conspectus of my submission in my written note. I'll come back with the judgment.
Submissions from the Keshwanand Bharti's case
yes,
onward.
Correct.
And then Alchakal Kumar also take it when Article 323A and 3 was involved.
23B.
Whether he was not a question actually.
23A
was a question. So it says that whether 226 powers is taken away.
Correct.
But you have a legislative yeah.
Correct.
It says it's a basic structure. You can't change it.
Change it.
You only, I'd say the twist was that instead of single bench, it goes to a division. Nothing further.
That's why I was saying that I should not read the statute against me and ask for a quasi. I mean, quasi on the ground as a...
Come back, then this can't be. It's a wider one, and which imbibe every kind of...
I'll come back. I have done it.
There cannot be a complete embargo.
Correct.
So that is what we
I'll come back with that. I'll come back with
the
assisted that. Yes. That's what is my main proposition is that judicial review cannot be taken away by legislative actions.
I understand, sir, but he was...
I'll come back to material.
When you are there, then take out some people from your armory.
I'll come back to that. Everything with a proper written note now this time. This time an extended for written note, I'll give it.
If on that, thereafter we'll consider whether you are an SSC or you are not an SSC.
Correct, I'll come back.
No problem.
Yes, I'll come.
You are not an SSC, not an SSC. Cross that particular basic
barrier. Correct. I'll come back. Lord, in the meantime, they have issued the demand on 28th of August. I mean, the recovery proceeding, they have initiated.
You are a National Highway Authority, a government of India's initiative. What is the difficult?
There is a risk.
It's really from a Caesars to a Caesars 5. What more?
But it's a profoundly, barring perhaps that limitation, perhaps will.
Nothing is going to happen. They're not flying away or fly-by-night operators that they will flew away and you will not catch hold of. They have a substantial amount, substantial assets throughout the country. So, come on, when I fix it.
18th.
18th, come on back in.
Until that time, at least.
Yes, we can't fly away.
Item number 23.
Lordship, in item number 23, junior standing Mukesh Agrawal was appearing in this case, and he has given to take instruction. He needs 2 days time. He could get the instruction. Let matter may fix on Monday.
Well, item 24.
Madam, I am VC. That is regarding 73(4)(b) of service tax.
These are counterpart.
Yes.
Please pass on. Have you seen the order?
So, Madam, these are already admitted, these are fixed for today. So, we have to wait for the outcome of the apex court.
It is still pending before the Supreme
Yes,
Court has
ma'am.
not been decided. That is what we wanted. No, renewal order is already passed in the matter, adjourned for.
So, it is fixed today. It is fixed for today.
Is next.
So, interim order may not continue this.
That is what is.
Item 25. Well,
The last in the that is to WPC number 23766 maybe. These are all same question. That's what coming. Lordship, I can take up which one? 23766. That's the 4.
You are appearing in that all the matters.
I'll know one submission. I have submission.
You are appearing in this matter as well. 23766.
Yes. Yes.
What do you say?
Well, this matter is pertaining to reassessment proceedings. Here the petitioner that remarks that the notice has been issued under section 138 by the judicial assessing officer instead of faceless assessing officer under section 151 capital M. So when the similar matter already is pending for disposal, it will be tag off.
Which one? Yeah, my knowledge I have 9.
Yeah.
And in fact, I'm just helping of this situation. At least Savior of the High Court has already held that
He
they
says that
cannot.
there are other matters which are already there. What is what is the number?
Well,
So asking the same thing.
And the similar matter today also the review petition that was pertaining to that matter also. So,
We are not dealt with that aspect.
no.
We have two notices.
Right. That.
So that maintain different angle or view. What would happen when you just to restore then why are we mentioning? Is it an issue? Whether an issue of 148 notice.
Right.
And the order under section.
Not in consonance with section 151.
Right.
Whether it
That is the next knowledge.
whether it is pure question of law or this question of law, it should emanate from your assessment because where once you are certified on the basis of assessment record that the baseless assessment has been done in consonance with tax provisions. Otherwise, it will fall within the parameters laid down in service.
Yes.
Four categories have been envisaged for invocation of Article 346 isn't it?
Yes, ma'am. And this has been issued by the authority.
Each case is different, sir.
Well,
Each case has to be analyzed. That is what Ashish Agrawal has. Ashish Agrawal has,
yes, ma'am.
each case has to be seen in that perspective. You can't omnibus with each case.
Each case.
148A is clear.
148A and 148.
No, 148A is clear. You have been dealt with correctly.
By the jurisdictional assessment authority.
148A1 given.
Yes, ma'am.
148A2 you replied.
Yes, ma'am.
Raise it or on facts.
On facts, I say
148A3 order was
yes, ma'am.
passed. Along with that, 148 was
Yes, notice. Yes.
given.
Yes.
So now the question is,
These have been done by the jurisdictional assessing officer in and the mandatory provision in 151A says that this ought to have been both 148A as well as 148 required to be dealt with by the first class assessor. This is mandatory and
so 148A was not
neither
issued by cases.
no neither 148A1 notice nor the notice under 148. Nothing has been issued by the specialist. It's only jurisdictional assessor. And all these seven court's judgments have been there. It cannot be done. It's mandatory since 29th March 2022. The rule has, I have annexed that, Annex 13 P 134.
This court's order, Mr. Jagun sir was cited. This court's order.
That not very right. Just to prove.
This court's order. That like. Mr. Jagun sir's case, today's review.
That's what I've heard it.
But today he is not so
Lordship, at page 8, I have quoted 151A. And it says that 148A order and notice, 148 notice is required to be issued under by faceless. I've quoted. And this became mandatory with effect from the 31st March 2022, in the last part of that provision. At page 8, my Lordship can happen.
Business unit can only issue that.
Only. All now assessment, reassessment, notice, everything is to be done by them. Lordship can have that central page 8. Central government.
Central government will
scheme by notification the office will gazette for the purpose of assessment, reassessment, recomputation under section 147 or issuance of notice under section 148 or conducting inquiry or issuance of so-called notice or passing of order under 148A or sanction for issue of such notice under section 151 so as to impart greater efficiency, transparency and accountability. Now, my lord, the notification they have issued, I have annexed at page 134. That is dated 29th March 2022. Annex 10. In exercise of the power conferred under subsection 1, 2 of section 151A of the Income Tax Act, the central government hereby makes the following scheme, namely
Incompetent, that has.
Yes,
Yeah.
another obliged one. That's it.
Here, gives us answer to 151A. Including the order under section 143. It is really a preparatory provision in contemplation to initiate a proceeding or issue a notice under section 143.
Yes, sir.
So if that is also required to be done in a fiscal assessment.
What is the assessment period?
1920. This day, when I'm months before, yes, ma'am. Limitation expiring on 30th June. For the purpose of 148, they have issued the order notice under 21st May.
So at that,
Flag.
during 1920, the law was something else.
Law was not, this was not. Yes, ma'am.
So this business has come.
21.
22.
21, but this notification come in 22.
Yes.
And when the first time the notice was issued?
First time is issued in 2025.
2025.
20.
That's 148 A1 notice. That is
25.
Yes, ma'am.
So after
After
this enforcement of this.
Yes, sir. What is your answer to it?
I may be permitted to tell you.
Well, it says that it
No,
cannot.
it is like, mandatory permission, madam, to issue the test days. Notification at 29 March 2022.
So they cited 12 judgments minus Odisha High Court judgment.
Yes, has to go. By all means.
Now, these challenges they have made to the Honorable Apex Court has also been dismissed.
They challenge this from which order?
From Telangana order, Your Lordship, can you have that page 2 of the compilation? This order was challenged. Actually, this order noted down the writ petition. The other, Lordship, can you have that page 3? The Law and Council for the parties fairly and jointly all that the point involved in this case fairly covered by order passed by the Sonal Court in WPC number so and so. Date 25 and batch up. That judgment is mellowed in that page 5. 13353 up to that 5. And the SLP is mellowed at page 1 is arising out of
Patlula is.
yes, ma'am. 23573 of 2024.
Simply has not decided.
No, my lord, it says that there is one.
One line.
No. Having heard the Law and Council appearing for the
No reason. No reason to interfere.
No, leaving. My lord, we found no good reason to interfere with the impugned order.
So what? The simpliciter dismissal of the SL. Simpliciter dismissal.
Yes, ma'am.
Remember. And you check up.
2000.
Yes, that is the not contesting.
We check up this Vishwaja Dagara versus Assistant Commissioner Income Tax 2023 SSC Online Odisha 709.
Yes. Can't be sustained. Apparent lack of jurisdiction. Yes, that's the goal.
Any permitted for some time.
My brother is more interested in giving you in ventilation. So wanted to give you an opportunity to come back. When also.
You take the number of citation, take up.
Yes, but I'm giving it for
Patlula case is, let's just your issue.
Next week. Next week. 2 weeks time. Why? 2 weeks.
Before that,
It's a institution of very high position. It's the institutions actually, the institute, petition is the institutions created by the Act of Parliament.
Oh, I understand, sir. You are a national.
So I pray that
Institute of Technology. Laukela.
I am not required to pay income tax under this.
Whatever.
That's different. But they may not.
No different. Yes.
And the interim membership.
Interim.
Well, they,
after 2 weeks, 148. Student notice they wanted a reply, will consider it. If it goes, it goes. Everything will go.
Item 26.
The other matters, all the other matters are same as same.
Give the number.
Well, it is
In the list, well. Put it in list.
Think that.
Yes.
It's called.
Item 26.
That's the only one.
26.
26.
It had.
The petitioner has been rejected on the ground of delay, though the petitioner has filed the appeal within the period of limitation. And your lordship's covered order are there. I have made necessary corrections in the order.
Yes. Yes, it's for the next.
Item 27.
Cancellation, RC cancellation.
Twenty-eight.
Option relating to 73 for me.
29.
This matter is against 73, 48.
Item number 30.
Your lordship, this is a matter relating to promotion. Before going into the matter, I'll just point out one of my mistakes in page number 1. Just to be rectified, if your lordship permits. Only IA year, filing year has been wrongly.
Item 30.
It should have been 2024, but it has been written 2014.
Where? First page,
Order.
where?
Item 30.
Page number 1.
30.
Cost title.
First title.
No, cost title says
2014.
yes.
Yes.
It should, as paragraph 2, it should have been 2024, filing of IA year, but it has been inadvertently written 2014.
Yeah, this IN number.
IN number 6.
991 of 2000.
2024, it should have been 2024. Yes, but inadvertently it has been written 2014.
It is pointed out by the learned advocate for the prisoner that they main order, the this.
So this is actually earlier a order was passed in my favor, but later on I found it there are some factual mistakes. So to remove that factual mistakes, I filed an IA, and in the IA the main read petition was dismissed and order was reversed.
What? In the IA, it has to dismiss.
Yes.
Where is the IA? Show us. Can be next.
Yes, yes.
Where is the IA?
In IA which it was dismissed, it was Annex 5.
What was the prayer? IA is what prayer? Where is the order of 28/11/2024?
And showing rules.
The writ.
This one. This one. It is bold. Yes, this one.
Your Lordship, kindly come to page.
I have read it.
Page 164.
I have read it. I am talking about the order which is 28/11/2024, which they sought. 177.
Sir, page 164. Kindly come to page 164.
This is 164. The repetition was disposed of.
Yes.
And while disposing of the IA, it has been dismissed.
Yes. Sir, I'm showing just kindly have a glance to page number 165.
What was the factual error? Please, 1 to read of that order.
Sir, if your Lordship permits me, I will just in nutshell describe the facts. So it will be very clear on why it was dismissed.
Notice. Wait for the other side. Are you appearing?
Lord, I am appearing. I'll take notice of 1 and 2, but for opposite party number 3, my Lord, notice has to go. A copy will be served on Mr. S.N. Patnaik.
Serve the copy. Can you come back?
I can give you. Yes, sir.
Mr. S. N. Patnaik appears for S. N. Patnaik.
Have you got those lines of judgment? That in the guise of a modification, the court cannot do the review?
No, sir, I have to search it.
You have to search it.
Yes. Sir, S. N. Patnaik, who is counsel for OPSC.
Sir, first you prepare yourself.
No, sir, I am just wondering, he was earlier counsel of this case.
Please, we are issuing a notice. Please serve him a notice. Give a copy.
He neither appeared in the original.
Whether he appeared on the day when the impute order was passed.
No.
Neither original order nor the recorder. The substituted.
No.
He did not.
No.
Will you pray for dispensation?
Let him appear for case. I have no question.
For the first day.
KC Mahapat.
Normally appears for the opposite party for responding number.
KC Mahapatra is petition in itself.
I am KC Mahapat. Yes, Kirod Mahapat.
No. Notice my election.
Speed post.
He knows the requisites that can be to him. He knows that.
You file requisites.
Yes, I have filed requisites.
Can file review. Code file review.
सेटा तो मु से मोहरी से ताको दे फाइल कर
Register file.
अच्छा
केवल सुधा दे.
7 days दिया था टाइम
7 days.
3 days दिया था ना
Notice my bill, but 1 and 2 which was clear. ଆପଣ extra copy ତ ଦରକାର
No. Extra. Whatever is there.
करेक्शन करा था कोई जानी चाहिए नहीं क्या करेक्शन
Mr. Mishra.
I'm ଆଇଲି
କରନ୍ତୁ
ଆଜ୍ଞା ମୁଁ ଆଇଲି
ଆସିଲେ କଣ
ନାଇଁ ମୁଁ କରେ ଆଇଲି
ଯାଇପାରିବେ ନା
नहीं कौन नेक्स्ट आइटम 31
maybe pardon. Date may be for next.
well in which sir item 31
Last year, the last year directed the state council to take instruction why the appointment of the women self-help group was cancelled after 1 month and 2 days. Now, page 128, the Lordship had turned to, as per the order passed by the Honorable Single Judge, my lord, the appointment order was issued, my lord. And thereafter, the very next page, 129, and that was cancelled, my lord. And the opposite part number 5 and 6 have been engaged, though there was a categorical direction by the Honorable Single Judge not to give them extension, my lord. Page 83, the judgment, and relevant page is page 116, my lord. Paragraph 44, my lord. Right, next, my lord. Since the tenure of the opposite part number 7 and 8 have been completed and the agreement period is over, the prayer to set aside their selection and appointment as THR to deal with preparation and display by letter dated such and such needs no further order. However, it is made clear that in terms of 4.1 of the agreement, no decision shall be taken for renewal of the contract in favor of opposite part number 7 and 8. Here they are 5 and 6, ignoring the case of the petitioner's agency. And thereafter, my lord, page 128, this order was issued, my lord. Opposite part number 5 and 6, their extension was up to only 31/3/2025 and petitioner's SSG
So
allowed
you challenge this.
Huh?
So you challenge this order of extension.
No, madam. And that next page, my lord, cancel. Cancellation. Madam.
Oh,
Next page, madam.
cancellation of?
Appointment, my lord. My extension was again cancelled, madam, without any reason behind my back.
What are you doing?
Serial number 3, bold letter, madam. Serial number 3, name of the project, Balasar Municipality, name of the SSG, Krupajal, allotted to produce and distribute so that till completion of the selection of municipal area as per the order passed by the Honorable High Court of Orissa is hereby extinguished. Secondly, to avoid food interruption, area May 25 onward, the two SSG, Joy Ma Durga and Ma Durga, opposite of 5 and 6, they have been engaged. Page 129.
129.
Yes, ma'am. Next page. Bold letter, my lord. Serial number 3, name of the project, name, Krupajal SSG petitioner, allowed, ward number 10 renewed, allowed to produce and distribute Satwa till completion of fresh selection in municipality area as per order passed by Honorable High Court of Orissa in WPC of such is hereby extinguished. The next manner, second, to avoid food interruption in municipal area on May 2025 onward, the two SSD, May Ma Durga and Ma Durga SSG are directed to prepare and supply Satwa and in Balasar Municipal till further order. They have been prohibited by Honorable Single Judgment. They have been again engaged.
How can it be done?
Yes, ma'am.
My lord, if my lord will see the impugn order passed by the Honorable Single Judge, my lord, that is not matter, not been gone into the merits, my lord. It has been dismissed and the order has been passed on the premises that alternative remedy lies. Liberty has been given to the petitioner. My lord may see page 144.
What is alternative?
My lord may see page 142, my lord, which is
Yes,
part of the.
on past occasion, I have said that your lordship wanted to decide it on merit since it has been cancelled on 1 month after. That's why your lordship wanted to decide it on merit.
What is the statutory?
My lord, it has been taken note of at paragraph number 7, my lord, 7, 8, and 9, my lord. Says that in terms of the said guideline, the contract has been executed, the non-renewal of which is the subject matter of challenge. For convenience of reference, the clause 7 under the hearing termination of contract that's reproduced. And then we'll all cover it here. The Honorable Single Judge says in the factual matrix of the case at hand, this court is of the considered view that in terms of the language of this said termination of contract, which also binds the petitioner being a party in terms of the connotation of the said term party, so used in the said clause, there is effective alternative remedy which can be availed by the petitioner. Hence, this court is not
What
inclined
is
to.
the alternative comprehensive remedy? Say that.
Yes. But that lies in the contract, my lord. No, that has been quoted, my lord, here at page 1.
What is the alternative? When you are taking out each show that where is the alternative?
They say that the director of special project appeal lies to director of special project.
If any question
Here,
or
there is no contract.
No, my lord.
Here
It
there
has
is
been
no
quoted,
contract.
my lord. It has been reproduced, my lord, in the order
Yes.
itself. If any question or dispute shall at any time arise between the parties, it shall be referred to the collector of the district and appeal shall lie before the director, social welfare or any other authority as may be prescribed, whose decision shall be final, conclusive and binding on both the parties. In view of this provision, my lord, the Single Judge has said that because there is alternative remedy available, that can be taken recourse.
When there is a apparent case of the action having taken contrary to the mandate of the High Court judgment.
That on that, my lord,
Then can it be sustained?
On that score, my lord,
should protect the majesty and the sanctity of the court.
On that score, my lord, I'm not submitting.
How can it be?
I'm only saying, my lord, on what grounds the order has been passed, that I was bringing to my lord's
That should not be.
My lord, as my lord's thinking, that
give me that two portions, the page where the quotations are.
Yes.
there.
Page. One 116, 115 and 116, paragraph 43, 44, madam.
So it is not an absolute bar. It simply says that no decision for renewal shall be taken without considering you.
Yes.
So
Thereafter, my lord, renewal was taken, my lord, page 128.
One?
128, page. Letter number 1378, dated 29/3/2025. Opposite serial number 1 and 2, opposite part number 5 and 6.
You are the
Opposite. Yes, yes.
SSG.
Yes, ma'am. They are renewal up to 31/3/2025. Right hand column.
So all the three were engaged.
They are renewal up to 31/3/2025.
And your appointment?
Was allowed to produce and distribute till a fresh selection is made.
Fresh?
Till a fresh selection is made.
Correct.
Next page, my lord, cancellation.
Within 2 months?
Within 1 month and some days. And the penultimate paragraph.
Uh, 31st March 2025. Now everything is over.
They are, my lord. They are case.
So they are also gone.
They have gone, my lord. Again, they have been inserted by virtue of this order, page 129. Penultimate paragraph. Secondly, to avoid the food interruption municipality area, the two SSG, Joyma Durga and Ma Durga, are directed to prepare and supply in Balasan municipal area till further.
Rejected.
My lord?
Your case was considered and have been rejected.
No, my case was not rejected.
This is what your case is rejected because the government, the finance department,
yes,
they have raised an objection and the proposal is rejected. Government has made a remark that
there was no question of referring the government, my lord. Government is nowhere consultant, but government, collector is the authority under the guidelines.
129 first paragraph.
Yes, madam. With reference to the subject cited above, it is to mention that in response to our proposal seeking additional engagement of third SSG, there was no question of third SSG, madam. The court has said not to extend the opposite part number 5 and 6.
No, it does not say. The
Yes.
court has simply
Yes.
says.
Yes. Ignoring the case of the petition.
Since the tenure of the opposite party number 7 and 8
yes,
have been completed.
Yes.
And the agreement period is over.
Yes.
The prayer to set aside their selection or appointment to deal with the operation in supply.
Yes.
It needs no further order, means the explanation was done.
Yes.
However, it is made clear that in terms of clause 4.41
Yes.
of the agreement, no decision shall be taken for renewal of the contract in favor of the opposite parties number 7 and 8, ignoring the case of the petitioner.
Yes.
That means there was no complete embargo. Only thing is, while considering the prayer for renewal, you should also be taken into consideration.
Yes, madam.
So your consideration was there.
Yes, my consideration was
Engaged as a third.
my
You were
consideration was
considered,
my
But the government regretted the.
no, my consideration was 128 madam, page.
Probably you could not get
Yes, madam.
to raise the issue.
Yes.
Which clicked my
Yes.
mind.
Yes, madam.
But after reading the language, I do not find the way you have interpreted the order.
No, my lord.
Is correct.
My lord, dear lordship, see why it was referred to government, my lord. Why it was referred to government? There was no question of referring government. Clause 12 is the renewal clause. Once their contract is over, 31(3), and I was allowed to continue, that means one SSG is there. There is no question of any 3 SSG till the order is passed by on 3/5/2025. Once their contract is over in 31/3/2025, one SSG is continuing. Only the petitioner is continuing, madam.
How can it,
My lord,
can you continue?
Yeah, lordship, see 29(3) order.
Not awarded, you have worked since only till March 2022.
No, my lord, last column, my lord. Allowed to produce and distribute till completion of fresh selection in the municipal area order passed by the Honorable High Court of Orissa in WPG, madam. Page 128, madam. And so far as their case is concerned,
That
madam.
was in terms of the order of the High Court.
Yes.
But you were not awarded that particular contract
Yes.
after 2022. Your grievance was
Yes, madam,
that
that's-
these persons are continuing and their contracts are being renewed and you are deprived. Then the court says that no, that cannot be done. If the fresh tender is invited, you may be permitted and your past experience
Will be counted.
counted and the preference would be given.
Yes. There was no advertisement, madam.
And then say that while renewing their contract, you should also be considered.
Considered, madam.
So they considered you.
Yes.
And thereafter the government rejected it.
Government has no power, madam. Your lordship, see 51, page 51, madam. This is the guideline, mode and manner of selection, madam. Clause 12, madam. 12(2). Before the end of 1 year, a review of the SSC performance should be made by the collector, after which a decision can be taken to either renew or rescind the contract.
Correct.
There is no question of referring the government, madam. Seeking a government's permission, madam.
Maybe if they have gone there, then what more? The collector is really discharging the function of the sovereign government.
I was continuing since 2012, madam. Only in 2022.
2011, you were continuing from 2011.
Yes.
Till 2022.
Yes.
Thereafter you did not.
No. In 12, madam, I challenged that. Their selection was challenged in WPC number 20670, madam. In that, court has directed to consider my case along with them, my lord. When extension was made, madam. An extension was made, given to me, my lord, and their contract was up to 31/3/2025.
Okay, now the question is that they are allowed to continue. You were not a party there. the order appointing them or selecting them was not caused and set aside by the court. Court simply says the tenure or the period has expired, no further order is required.
Yes.
That means so far as their selection remained unchallenged, uninterfered with, and if they were allowed and their initial appointment or the selection is not found to be illegal, if the authority wanted to renew under this contract.
Their renewal is up to 31/3, my lord.
Now, my question is that
Yes.
up to 21/3, that has also expired.
No, that was expired, my lord. Then
Now in 129, their period is also extended until further order when the fresh advertisement will be made.
no, fresh advertisement is not made.
They have to make.
Yes, my lord. Now your lordship see the language of page 128, my lord. Page 128 language, your lordship see on what basis selection was made, my lord. With reference to my place, with reference to the subject cited above, it is to inform you that the district level renewal committee Baleshwar has been pleased to renewal existing THR unit in your concerned project. As per the order passed by the Honorable High Court of Orissa and such, Procedural SSG may be allowed to produce and distribute THR along with other two contenders, such and such, in Baleshwar municipality. In this connection, district will be sent a requesting letter to the department for engage of all three SSG regarding to produce, distribute in municipal area. Then, my lord, while the renewal was made, my lord, their renewal was up to 31/3/2025. And I was allowed to continue till a fresh selection is made. That means, my lord, they are no way in picture, my lord. Then where is the question of sending the government to accept whether my engagement was correct or not, my lord? They are not in picture, my lord. 31/3.
One thing is certain. This relates to a selection process of 2023.
Yes.
You were nowhere in the picture in 20.
No.
These two persons were selected. Then you challenge the selection.
Selection.
While disposing of the repetition, the single bench did not find that their selection was illegal or the defective or wrong. The single bench simply abruptly jumped to the conclusion that by the time when the writ petition came for final disposal, their period of engagement has also
Over.
expired. So no further order is required. Now, the effect of this observation, what does it? The effect of this observation is that their selection was not found to be illegal. Otherwise, the court would have said and cautioned.
No, by that time it was not quashed because the time was over.
Sir, that means that their selection was uninterfered with. Please consider.
Yes, my lord. Yes.
That selection was not. There is nothing which says that their selection was wrong. So their selection was found to be legal. Now, the real catch that comes. The court says that as per the clause of the agreement, they are entitled to a renewal.
Yes.
If their tenure is renewed, means they are allowed to continue.
Yes.
Continue under what? Continue on the basis of a valid selection. Then you cannot be ignored. You should not be ignored.
Yes.
So their tenure was renewed.
Court said, my lord, that renewal cannot be done.
You were considered.
No, court said, my lord, renewal should not be made. It should be made by selection process. Court
No.
said, yes, my lord.
No.
44, my lord.
Please
Paragraph
come to
44.
know, come to read it.
Paragraph
Read it.
Yes, my lord.
Page 116,
16, my lord.
Yes.
Yes.
Please come, read.
Since tenure of the opposite part number 7 and 8 have been completed and agreement period is over, the prayer to set aside their selection and appointment as THR to deal with preparation and distribution of THR by such and such needs no further order.
What does it mean?
Yes,
That
ma'am.
means the legality of their selection and the appointment as TSR was not interfered with.
Court has said not to interfere because that was there.
Next.
However, it is made clear that in terms of clause 4(1) of the agreement, no decision shall be taken for renewal of contract in favor of opposite part number 7 and 8.
Don't stop.
Ignoring the case of the petitioner.
Please,
Yes,
that is what I don't
Yes.
stop.
Ignoring the case of the petitioner.
So what does it mean? That while considering their prayer for renewal,
Yes.
you should not be ignored.
Yes.
So you were not ignored. The authority said that all these three, I am renewing their contract and also engaging you, you continue.
A time limit was fixed, man. A time limit was fixed.
They eternally, perpetually. Let us go to that extreme. Perpetually, eternally. Later on, the government says, I am not going to approve it because the selection was only for 2 suppliers. I will not grant a third supply. They did not grant an approval and terminated. Can you say that this was violated because they have not ignored you? They considered your prayer. They did not ignore you. The spirit of the judgment is that it does not mean that you have to be given. Otherwise, court would have issued a mandamus. Given.
No, by that time the period was over. The government, it is the government matter who
The
should.
language is ignoring means that you should be taken into consideration.
Selection was not made, my lord.
Sir, it's a renewal.
Renewal, my lord. It's a renewal was made.
So in that event, you were an outsider, not a selected one. So government said, I can't give you a approval for a third without anything. What is the wrong? I'm just asking. I think some germs has been injected in the mind of your client.
No, my lord. So on 29.3 letter, my lord, your lordship has
That he is taking or they are taking shelter. 44 goes against you.
No, my lord,
You could have challenged this particular order, saying that why don't there be a declaration that their appointment is wrong?
By that time, the period was over, my lord. That's why.
That does not mean because there is a provision for a renewal.
Yes, provision for renewal is there. Provision for renewal is there, my lord.
So how can this liberty be granted? Ignoring?
That was not done. 128, my lord, your lordship has seen. 128 was done.
I am not able to
Yes.
the wavelength of
No, yes, my lord. I understand, my lord.
So that is what the trouble is. silent. It was a stand of the opposite parties and the stand of the state, and you remain silent.
No,
You
no.
have filed a writ petition.
Yes.
Seeking a mandamus or a certiorari to pass their selection.
But by that time, the period is over, my lord. That's why.
Whatever be the reason, then there was no necessity of 44.
So it should have.
The court should have stopped there. Now it has become infructuous. Relief cannot be granted. Writ disposed of. Why 44? Paragraph? No necessity.
44 was granted, my lord, because to consider.
Challenge that it can't be. Once it has become infructuous, then what is my right? I'm an alien to a selection process.
State has not made any advertisement for selection, my lord. They have renewed the contract.
Why you did not challenge this order, sir?
Yes, that was not challenged, my lord.
So
that was not challenged because.
What is trouble that troubles me?
No, because 128 was there, my lord. That's why I had not challenged. I have been selected.
128 is a this was you did not challenge, but you could have challenged this.
This, but since 120 in the meantime, my lord, I have been selected. I have not challenged that order, my lord.
And the moment of the very second day when you were thrown out, will you not challenge this?
I have challenged that.
Where?
Yes, I have challenged that. Yes.
This order.
This order I have challenged.
Which?
In this writ application, my lord, where the court has said the alternate remedy is available. That's why I have filed this appeal.
Which order you are assailing? Tell me in the appeal.
Appeal, my lord. Order dated 7/5/2025.
Is this an order dated 7/5/2020? I'm reading an order.
Yes.
This is an order dated 24/6/2024. I am reading this. 24/6/2024. Did you challenge this order?
This order I have challenged, my lord. This order I
have you challenged 24/6/2024 order judgment? Where you are referring to paragraph 44?
22/4.
Then you are referring paragraph 44.
Yes, that order I have.
Judgment. Have you challenged that judgment?
That order I have not challenged. Thereafter, what has happened, my lord? 128, page 128, I have been selected. When my order was again cancelled, my lord,
with humility and the respect to my command. This is the 100th time you are repeating.
Yes, yes. No.
And it is a 101 time I reminded
yes,
you
yes.
that what troubles me.
That your lordship. That's all. No, my lord. These three applications.
There should be some kind of a.
Yes, well, I
understand. The court
no, I understand,
be strict.
I understand what your lordship.
The court should be strict. The instant appeal arises from the judgment.
I'm obliged, my lord, because your lordship has rightly interpreted the renewal part.
I told
128, place 128, my
It
lord.
is not interpreted, sir. It is interpreted by the
Yes.
Supreme Court in
Page one-
Navashan Dulai's
Yes,
case.
for page 128, page 128.
1989 or
Yes, yes.
88 Supreme Court.
Sorry, page 128, it was written, my lord. It was written, ward number is same, 10 and 10.
I have said
Yes,
that is
yes.
the record number 5.
Tomorrow, my lord.